Good morning, everyone. Welcome back to this beautiful venue of the Bucerius Law School for our second day of the conference. I hope you did enjoy last night the dinner and the talks over dinner as much as I did. So thank you for being there yesterday evening. Thank you for coming back today. We have a busy day today with our next two panels. The first panel on responsible shipping and green shipping. So yesterday we were setting the scene, we were talking about ports and port state jurisdiction. Now we get more specific with regulations of shipping, and then after lunch we have another panel on resource responsibility. So I'm particularly happy to introduce our first speaker today, Professor Dr. Aldo Kirchhoff from the School of Law at Dalhousie and Halifax, where he holds the Canadian Research Chair in Maritime Law and Policy. So Aldo is one of the leading experts for ship emissions and all other, I should say, shipping issues in the Arctic and beyond. And I'm very much looking forward, Aldo, to your ideas on responsible regulation of ship emissions in the context of climate change. So thank you for coming.
Okay. Well, good morning, everyone. And like the previous speakers, yesterday's speakers, I'd like to thank the organizers, especially Nele and Alexander, for inviting me and to be able to come and participate in the fourth conference in this series. I must say I participated in 3 out of 4, so I'm doing not too badly. And it's been wonderful, I must say. Every time it's been a really interesting meeting, an opportunity to network and, of course, meet old friends. So the topic I've been invited to speak to is the subject of the international regulation of shipping from greenhouse gas emissions. And indeed, I would suggest that this is one of the most difficult topics in the regulation of shipping that we have ever had. And indeed, it's not a topic that we can address and dismiss quickly. Rather, it's a topic that we're going to have to live with for the next few decades. Why? Because this is all about the gradual decarbonization of shipping. And shipping essentially is very heavy energy reliant, and that energy is dominantly from hydrocarbons. So I thought I'll speak to you on this subject, and in particular, trace a relationship between, of course, the initiatives of the IMO as the maritime regulator, and, of course, the framework within which it is operating, the Paris Agreement, and specifically meeting the goal of the Paris Agreement. So by way of an outline, then I'll offer a few introductory words. I would like to point out the regulatory complexity. Why is it so complex to regulate shipping? And then, more specifically, of course, emissions. And then introduce you to the IMO strategy for greenhouse gas emissions, or I should say, initial strategy. And then offer words about the delivery of this strategy and offer concluding observations. So, by way of introduction, going to the Paris Agreement, you will all recall here the overall target. Essentially aim at a temperature increase of no more than 2%, and ideally aim for 1.5 degrees centigrade. And you will recall, of course, that the Paris Agreement relies very heavily on a system of nationally determined contributions, right? Well, shipping is not expressly mentioned in the Paris Agreement, and indeed, it was intentionally so, although there were attempts to include shipping and aviation, but it was thought these industries are so different, they're so transnational, so global, they wouldn't really make an easy fit in terms of the responsibilities of states to report their nationally determined contributions. However, maybe they were not mentioned specifically, but they still had to contribute fairly to the achievement of the goal. Now, for us, of course, in the law of the sea, we know that we have a set of obligations here that do oblige states essentially to tackle atmospheric pollution from ships. First of all, you will recall Judge Pike yesterday reminded us of Article 192, this fundamental duty to protect and preserve the marine environment. And indeed, in the jurisprudence now, we know that there's essentially an important due diligence responsibility here, and indeed to take active measures. So in other words, sitting back is not good enough. States are expected to actively engage to resolve the problems of the marine environment. Now, I will remind you too that we do have a number of other relevant provisions here. Article 194, the duty to minimize pollution from ships, and of course Article 212, more focused on atmospheric emissions, and indeed accompanied by Article 222 with essentially a duty to enforce. And these duties, of course, require a high degree of international cooperation. And we've seen indeed that cooperating to achieve the purpose of protection and preservation of the marine environment is indeed part of the general duty to protect and preserve the marine environment. And of course, what do we have to facilitate this? The IMO. With respect to international shipping, it is designated as the competent international organization with respect to international shipping. And I emphasize the definite article D. Now, there are, of course, a number of international organizations that also address shipping, but clearly when it comes to the regulation of navigational aspects of shipping as distinct from the commercial side, carriage of goods, for instance, clearly the IMO is the organization that is responsible, and therefore, under its own convention of 1948, it has been established as the machinery through which states cooperate to develop international rules and standards for, of course, domestication and enforcement, whether by flags, of course, also coastal, as well as port states. So for us, the IMO is, of course, the linchpin of the system of international maritime regulation. Now, going to ship emissions, how much of a problem are we actually talking about here? Well, shipping, if we look at some of the data that we have, which admittedly is dated, there were a number of studies that were produced by the International Maritime Organization, and two of these in particular stick out, and they are the ones that, in fact, we are using to push forward our efforts with regulating GHGs at this time. Well, the second GHG study of the IMO, published in 2007, essentially indicated that shipping generally emitted about 3.3 of global CO2. And international shipping, specifically 2.7. Now you think, wow, why are we getting up so much fuss here? It's such a small percentage. Yeah, but the small percentage is equivalent to Germany's emissions or the United Kingdom's emissions. So imagine if we were to leave Germany or the United Kingdom outside the Paris Agreement. Uproar, right? So shipping, of course, should not receive any more favorable treatment. Now, for us, of course, there is a range of GHGs that we ought to be concerned about, but clearly in shipping, CO2 is the major culprit. Now, if we were to continue on a business-as-usual scenario here, the study indicated that basically emissions by 2050 could increase anywhere between 150 to 250%, and essentially, that is also in part as a result of expected growth of world trade. And what we have to remember here is that anywhere between 80 and 90% of global trade is carried by ships, depending on whose figures use. The United Nations Conference on Trade and Development estimated it's more like 80%. Now, a study produced in 2014, updating essentially the earlier study, indicated that the projected increase with a business-as-usual scenario, in a sense, could be even worse, because 50 to 150% projected increase, even if we introduced enhanced energy efficiency measures. So, of course, this was very worrying. So, the IMO response here, and largely, of course, driven by the Paris Agreement, but not exclusively, because the IMO has been addressing emissions from ships for a very long time, long before the Paris Agreement. But nonetheless, the Paris Agreement was a real opportunity to push the organization into a direction that was absolutely necessary. So basically, I mentioned this is a complex area to regulate. So why is this the case? Well, we have to remember that ships are mobile on a global basis, and they are owned transnationally. So essentially, you can have a ship with a very international crew. It may be flagged in Malta, where I was born, but the beneficial owners may be in Greece, Cyprus, China, Germany. And then, of course, you can have a situation where, of course, corporations own corporations. So there is an endless corporate chain behind ship ownership. Now, this is not necessarily something which is intended to avoid national regulations, perhaps taxation, and so on, but it is actually a system that has developed historically to spread the risk, and also a system to enhance ship finance. So in a sense, it's not surprising that we have the system that we have. Now, you may own the ship, but you don't necessarily manage your own ship. Someone else may be navigating your ship. You might have a ship management company on the way. There might even be a charterer. So essentially, you can have a number of different actors that may or may not necessarily be in control of the actual navigation of the vessels. And then, of course, not all ships are the same. We have different kinds of ships that have different energy uses. And then, apart from that, we have to bear in mind some of the issues that were brought up yesterday with respect to ports. At the end of the day, ships have value because they can trade. And they trade because they enter into ports, load cargo, unload cargo. And today, of course, the world economy depends very heavily on just-in-time delivery. So ships are like floating warehouses very often. And therefore, speed, timely arrival is of the essence. So that is an issue for us when we start discussing things like, oh, why don't we get ships to reduce their speed? Yeah, well, it's not that simple. You still have to arrive in time in another port and not lose your berth, because if you lose your berth, you might have a few extra hours, maybe a few extra days before you discharge, and then, of course, that means that you incur penalties for not having discharged your cargo within the time limit allotted to you. There are issues of risk management and, indeed, amortization of investment in shipping, 20, 25 years, perhaps. So if we introduce a regulation today, we have to bear in mind that we have tonnage, which is subject, in a sense, to particular finance agreements. So we have to think in terms of how do you phase it out, basically. So you cannot simply say, look, we're going to introduce a regulation today, and by tomorrow, everybody's going to change. No. In essence, it's like essentially having a moving object at great critical mass, and somehow it needs to be slowed down while you start another one and try to build speed with it. And of course, all this has implications for world trade because of the heavy reliance on shipping. And the reality is, too, that the capabilities to administer shipping are not equal around the world. We have great diversity, and that's one of the major issues we have, essentially to ensure that international maritime rules and standards are applied effectively. Now, bear in mind that these issues all bear on the question of how to regulate GHGs, but at the same time, shipping is already the most heavily regulated ocean use. You know, depending on how you count your international instruments, but the IMO estimates that there are more than 40 conventions and protocols that regulate shipping in one form or another. And then the number of codes and guidelines is endless. So essentially, you have a very complex system of regulation. But the complexity doesn't end only with the maritime regulation. The reality here is that we are dealing with an issue which really brings into perspective how much of international law has been developed into silos. And effectively, we think in terms of mitigation in shipping. So in other words, our ability to reduce emissions from shipping, well, sure, we are guided here by a goal from climate law, international environmental law, Paris Agreement in particular, but of course, UNFCCC, Kyoto, and essentially, if we look at the climate regime, if I can perhaps simplify and call all these together the climate regime, as a starting point, But of course, we're dealing with ships that navigate, that use ocean space. We're dealing also with the international law of the sea. There are issues of jurisdiction of their ships, how the jurisdiction may be exercised, and so on. And of course, clearly, the maritime law dimension is how we actually substantively regulate ships. But there is also potential an international trade law dimension here, which was mentioned briefly yesterday. So essentially, we see here potentially a convergence of regimes, which can have implications for how we regulate GHGs from ships. Because in the end, in the event of disputes down the road, and of course, we lawyers will have to think in terms of disputes and dispute settlement procedures and mechanisms. Well, the issue with, for instance, international trade law here is that international trade law has its own dispute settlement system, separately from essential dispute settlement system that we have, for instance, within the law of the sea. And the principles and rules applicable are very different from those that would be applied in the international law of the sea. On top of that, of course, let's not forget there is a potential regional dimension, especially here within the European Union. And indeed, I think it was Henrik yesterday that mentioned the MRV, the system essentially for ships to report data on fuel usage, distances, and so on. Very important data that is going to be critical, essentially, to better understand how we ought to regulate emissions. Now, there have been efforts over the years, and I mentioned that the IMO is not new to emissions regulations. And indeed, the IMO's efforts here go back really to 1991. So 1991, that's before the UNFCCC was adopted, right? And effectively, that was an early effort at addressing air pollution. That effort developed gradually, leading to the adoption of MARPOL through essentially the Protocol of 1997, introducing Annex 6, very important instrument for my presentation. Kyoto Protocol 1997, you will recall a provision specifically speaking to Annex 1 states, essentially, and states here agreed to pursue discussions through the IMO to reduce GHG emissions from marine bunker fuels. So that was always on the IMO agenda since 1997. There's been a lot of cooperation between the IMO and, of course, the UNFCCC Secretariat and, of course, the SBSTA process, the scientific process. And that has been going on now for years and years. And the MEPC has been deliberating on GHG emissions really since 1998 with MEPC 42. In 2012-2013, we had very important deliberations at the MEPC that led to the adoption of Chapter 4, a new Chapter 4, the regulations on the energy efficiency of ships, introducing the Energy Efficiency Design Index, the EEDI, it was mentioned yesterday, as well as a mechanism, a plan called SAMP, the Ship Energy Efficiency Management Plan. Essentially, the EEDI was introduced as a mandatory requirement for new ships, but the plan, the management, the energy management plan was essentially introduced to apply to all ships to essentially enable them to better use energy and reduce emissions. But the really major development here was the adoption of this strategy as a result of a roadmap adopted in 2017, leading to the adoption of the strategy in 2018. So if we look at the regulatory roadmap, in essence, this is where we are. And you see there a timeline, in essence, from the adoption of the strategy in 2018, and basically leading all the way to 2023 with a series of steps to enable the re-adoption, but of a revised strategy. So what we had adopted in 2018 was an initial strategy, in essence, to try to frame present actions, but also future actions for the short, medium, and long term. And then after this first 5-year period, and on the basis of better data, we'll be able to project the long-term decarbonization plan. And indeed, this is the strategy. This is literally the table of contents. And for our purpose, of course, what is important to focus on is the candidate short, medium, and long-term measures. In other words, exactly what sort of measures are actually going to help us, hopefully, to reduce GHG emissions from shipping. But also important for our purposes is barriers and supportive measures, because here this discourse has important implications for equity among states. This is not simply the sterile regulation of shipping. No, we're talking here about potentially affecting routes and potentially the movement of trade and potentially, of course, distribution of wealth. So this is no simple topic. So let me take you through some of these critical issues. Important for our purposes is to think in terms of what are the ambitions of this strategy as a whole. And indeed, the intention here is to reduce the carbon intensity of ships gradually by using the EEDI, the Energy Efficiency Design Index. So essentially scaling up through phases in terms of gradually increasing the efficiency of ships. That's essentially what that acronym stands for. But eventually thinking in terms of reducing the carbon intensity with respect to transport work, so carriage of goods, passengers, across the industry by at least 40% by 2030, but continuing efforts so that by 2050 at least we'll have reduce this by 70% using 2008 as a baseline. And then, of course, if you're wondering what happens after 2050, well, the aim here is to continue to eventually decarbonize, wean the industry of hydrocarbons. So the idea is for emissions to peak basically as soon as possible by 50% while continuing to enhance efforts. So we have a number of principles here that guide us in this process, and Henrik mentioned no more favorable treatment tied closely to non-discrimination. We should treat ships, in a sense, in a comparable manner because they're owned by businesses, essentially, and they're in competition with each other. So they need a level playing field. So we cannot really start favoring one flag over another. But we're also concerned about common but differentiated responsibilities. Essentially a principle of international environmental law that somehow had to be reconciled with no more favorable treatment in the IMO. This wasn't an easy process, and indeed for a long time in the Marine Environment Protection Committee, discussions stalled precisely over how to reconcile these two principles. But now, of course, with the Paris Agreement, it's clear that it's not just CBDR, but it's CBDR in accordance with respective capabilities of states and in the light of different national circumstances. So for us, in particular, least developed countries, as well as small island developing states are in the forefront because they are the ones that are most potentially impacted. At the same time, regulation is supposed to be evidence-based while utilizing precaution. So how we do that is not that simple, but certainly at least this is a principle that is supposed to guide regulations in the IMO. So now we are already into the short-term stage, starting last year until 2023. We are looking at adopting three kinds of short-term measures here, potentially at least those are the ones that we are considering. There are those that are clearly within the IMO instruments, and there are those, of course, that are within the IMO instruments, but perhaps need some additional work, additional data to determine what their impact might be if we do proceed with these. And then there are others, basically, that do not really require any particular data. So essentially, we have three groups of measures that are currently being considered, and a number of states have already put forward proposals for MEPC 74 to meet shortly. So what are the possible short-term measures? Essentially, these are defined as actually helping to reduce emissions. They may be a mixture of mandatory and voluntary. If you look at the ABC that I showed you earlier, we could be looking here at accelerating the EEDI process, so force upon ship, this goal-based approach, essentially to increase efficiency, maybe with higher levels of percentages, extend the application of this index perhaps to a broader range of ships. Indeed, the so-called SEMP, the management plan, energy management plan for ships, at the moment it's voluntary. Make it mandatory and expand it to a broader range of ships. enhance the volatile organic compound controls as well. So those are clearly all within Annex 6 of MARPOL. But then there's a second group, B, route optimization, potentially explore speed optimization and potentially speed reduction. We have to see exactly what that might mean. And also promoting alternative fuels. And then ultimately, C, of course, encourage the adoption of national action plans. Port measures, in relation to yesterday's discussion, these could potentially be key players for our purposes, and so on. So, of course, there are a number of issues here, because there is the issue of impacts produced by all these measures, and who is supposed to determine what these impacts are. Clearly, proponent states are expected to indicate what they anticipate to be impacts, but of course, there will be IMO collective determination. The reality is affected states will also have to watch out for their interests. And of course, we do have the epistemic communities out there. In essence, the experts like people in the room here, and a number of organizations, NGOs, that are very carefully watching this discourse. But the reality is that it's not that simple. Let's take, for example, speed. So in theory, speed has been estimated at being able to reduce emissions by 1/3 for containers, bulkers, and tankers. These are some of the biggest ships that you really want to reduce their emissions. But in practice, there are problems. Slow speed is not necessarily the optimum speed for which a vessel has been built. There might be issues of safety and maintenance if you reduce the speed of ships. And also, if you reduce the speed and therefore you essentially mess up with just in time, you could be pushing shipping onto other forms of transport, maybe more road, more rail. Do we want that at a time, especially in the EU, where we're trying to promote short sea shipping? We want to move more cargo by ships rather than by road or rail, right? And if you have slower speeds, you potentially have longer voyages. What if you're carrying perishable products, agricultural products from Chile, Peru, that are supposed to make it to China? If you essentially reduce their opportunity to market these products, they might be out of a market. And then, of course, there's an issue here. If you reduce you reduce the speed of ships, there are already ships that are very efficient out there. Why do you penalize them? And then, if you have slower speeds, you could have potentially a problem with exotic species and biofouling. The buildup on the hull could be a problem. So it's easier proposed than implemented. So we do not really have full agreement on how to use this as a potential measure. But the port-ship interface that was mentioned yesterday, there's a lot of potential here because ships, after all, provide services in ports, but they're receiving services. So ports could provide, for instance, what is called cold ironing, so essentially power supply from the shore, as long as, of course, the power provided by the ports is in itself provided from renewables. There are opportunities to optimize port visits and a range of measures can be taken in ports. But the problem here, this is where perhaps the differences in capabilities between states starts shouting at us. Because not all ports out there may be in a position to necessarily provide the range of different fuels that we're going to be seeing on the market. So essentially, that could put some ship owners in a difficult situation and also might make some ports essentially uncompetitive if they are not able to provide the range of the diverse fuels that we're going to be seeing on the market. So those were the short-term measures, very briefly here, but there's already been discussion here for the medium term, 2023 to 2020. Essentially, we're going to see an expansion of these short-term measures here, but perhaps the most significant measure here for the medium term will be the potential introduction of a market-based measure. And this is going to be very interesting in shipping because essentially the IMO was not designed to do market intervention. The IMO was designed really to regulate ships, international rules and standards, but market-based measures such as, for instance, a levy on shipping, or for that matter, a cap-and-trade system. Well, these essentially are novel things. One will have to think in terms of how the governance system of the IMO can accommodate these, or whether we should rely perhaps on some other institution mechanism outside the IMO. And as you see, the more we go into the future, the long term, the fewer the bullets, because essentially, how far into the future can we look? And indeed, this is one of the major challenges we're dealing with. How do you manage uncertainty? The more we look into the future, the more uncertain things are, because we are going to be placing our faith in technological development, and that is why we're pushing goal-based standards. But the reality is that it's difficult to foresee perfectly when certain technologies that we know we will have in the future, when they might actually be available. There's a range of impacts here that will still have to be ascertained, and you will see here geographical, the cargo value and type potentially, countries that have transport dependency more than others, such as small island states, everything is connected to them by the sea, potential costs of transport, socio-economic impacts, food security issues for some countries, yes, this is also a potential impact, and so on. So there's a range of impacts that we still have to grapple our, we have to figure out essentially how do we even develop a methodology to determine these impacts. There will be, of course, a range of supportive measures, clearly on the technical assistance front in particular. But there are increasingly small island development states out there that are saying, look, supportive measures are not enough. We need systems of compensation. You have to figure out, basically, a system that will kind of insure us against potential risks and then compensate us. And of course, that is going to be very, very controversial. But if we look at the big picture, strategy delivery, so we're going to be relying very heavily on MARPOL, Annex 6, lists of measures, technical, operational, and so on. There will be market-based measures at some point in the future. We have to see when and what sort. And we have a range of structures that are going to be delivering on this system. IMO is the regulator, but let's not forget the industry organizations, International Association of Classification Societies, as well as the International Standards Organizations, among others. They play a critical role in maritime regulation that is not, to my mind, acknowledged sufficiently, but they are essentially central to maritime regulation. And ultimately, of course, how do you keep an eye on the system and make sure it's going to work? It's going to be very complex. Remember the silos metaphor that I mentioned earlier. So in essence, we're going to be looking here at a number of regimes that have to work together in gear. They're going to be, in essence, supporting each other. So clearly, the Paris Agreement is there, but maritime regulation plays a key role to feed into the Paris Agreement goal. Of course, we have the various jurisdictions in the law of the sea, those states that are responsible for their ships or that may have regulatory powers over ships moving to their waters or calling into their ports. There is a role even for private law, but critically, of course, let's not forget the role of capacity building, technical cooperation, and technology transfer. And then, of course, we still have to figure out where does the WTO fit in here, especially if there are disputes. And let me conclude here. I realize I'm now over my time. A few observations here. Essentially, the IMO has proceeded on the basis of knowledge that we've had really, which is now quite dated. And almost every month, there's something new that we're learning about climate change. And very recently, for instance, you will have heard that clearly the IPCC's report on 1.5 suggests that we need to be a lot more ambitious to meet the Paris goal. But look, a couple of other studies indicate that we still don't fully understand ocean thermal storage, and that indeed the oceans themselves might be reaching their absorptive capacity to absorb, in essence, heat and carbon. But a couple of weeks ago, we learned too that in the Arctic, things are a lot worse than we thought. That essentially 3.5 to 5% degree increase by mid-century is now locked in. So we're already well beyond the Paris goal in the Arctic alone. And we know the Arctic is the most directly affected, if you want, parts. Essentially, the Arctic is impacted twice the rate of the rest of the planet when it comes to impacts on climate change. So essentially, a range of other observations there. I will not go through all of these, but perhaps I would conclude with the last one. I really think that the introduction of market-based measures will raise some interesting questions concerning the governance of the IMO and whether perhaps we might see the need for some structural change in the IMO to be able to support a market-based measure. And I apologize for taking a little bit longer than I should have, and I thank you all for your kind attention.
took more time because we started a little late, and this is such an important topic that I'm happy to say we will come back with questions in the discussions after we've heard all three presentations. If you want to make use of this webinar we have set up, I think there's a possibility already now to save your questions. If you are afraid you will have forgotten them in an hour from now, you save your questions, ask them now via this button on our homepage to interact. Unfortunately, I don't think we can actually see all the questions and bundle them, but we can have a discussion, a live discussion, and also read your questions from the screen later on if you prefer that. We move now from one very timely issue to another timely issue, from climate change to marine litter. This is in the context of shipping, but we will hear now two presentations on waste, on litter in the marine environment, and later on particularly from ships. So I will introduce our next speaker, Aleke Steuffen-O'Brien from the World Maritime University in Malmö, the Sakakawa Global Ocean Institute. Aleke holds an LLM from Kiel and a PhD from Trier on regulation of marine litter in international and EU law, so that makes her the expert on the issue. Before she moved on to Malmö, she worked for the Secretariat of the Convention on Biological Diversity and for the Federal Environmental Agency. So again, we have someone who is firmly rooted in our academia, returned to academia, but has had a look on the issue from a practical side between, so that bridges to our last speaker that I will introduce afterwards, Anna from the European Commission. So without me talking too much and getting our schedule further out of time, Aleke, the floor is yours. Thank you for coming.
Good morning, everyone. Stand here, I'm quite short. Thank you very much for the invitation of the organizer and also of the Scientific Advisory Board. It's a really honor to speak here today, and I'm really happy. I come from Northern Germany, so I'm really happy all the time to be here. Yeah, today I'd like to talk to you about marine litter. It's an issue that we see. It's not like greenhouse gases that we sort of like cannot tangle or we cannot really perceive. So we know that we call our planet the blue planet, and it's supposedly really colorful. But if you look closer, it's not full of fish, it's full of waste. And we know that only from land-based sources, between 4 to almost 13 million metric tons of plastic are entering our ocean each year. And the German Environment Agency calculated that it would be the equivalent of trucks completely filled with plastic, driving around the Earth in 1 year. So it's a huge amount. We cannot even understand how much it is, I guess. I would like to frame my presentation on 4 hypotheses. First, marine litter is a very complex and chronic issue with many associated uncertainties and knowledge gaps. This is different to point sources, accidental sources, where you can really regulate and target one specific source, for example. It's a really sub-threshold issue. Shipping as a sea-based source of marine litter can globally be considered only as playing a minor role of marine debris. So the main part comes from land-based sources. I would like to send it out now. So addressing shipping is only one part of the really big puzzle that we have to work on the next few decades, actually. Then solving the marine litter issue can create dependencies of awareness, of really an active role of stakeholders that are outside of the marine environmental law perspective. I really enjoyed Professor Tchirkov's overview, where he said, it's a bit of like puzzle. We need to really work with everyone involved. And a lot of other fora have not the same perspective or not the same interest to address plastic, because it's maybe very convenient for them to use plastic. So keep that in mind. And I also like to argue, I'm happy that my former boss of the German Environment Agency is not here. I say that the amount of focus that's right now on marine debris has the potential to actually paralyze the effectiveness of the regime. And I will talk about that in the course of my presentation. So for the purpose now, I would like to use a very kind of old school UNEP definition of what we understand of marine debris. It's any persistent, manufactured or processed solid material discarded, disposed of, or abandoned in the marine and coastal environment. There are different versions of it, but I would just use it as it is now for this understanding. So it has to be something solid. And 80% of marine debris that we find is plastic, so this is the major focus as well. Setting the scene, I know this ratio, we usually say that 80% of marine debris comes from land-based sources, 20% from sea-based sources. There are some fights in the scientific community, but I would just leave it as it is. Here in the North Sea, in the sort of area around Hamburg, we know that this ratio is actually the opposite. So 20% comes from land-based and 80% come from fishing and shipping, and this is proven by monitoring activities. We know that right now we have 311 million metric tons plastic that's produced each year. It was from 2015. And there are a lot of leakages in the system. So the plastic that we find in the ocean are associated with our consumption and production patterns. And we know that by 2050, at least this amount will be 3.5 as much. So that's why we need to now address this issue not in a really piecemeal, sub-threshold way. We need to have systematic changes when we want to make a difference to this problem. Yeah, dealing with marine litter is en vogue. Every time I say, oh, I work with marine litter, I literally can see the eyes rolling in their heads, oh, not one of those again. And I understand it. Marine litter is one of the few substances in the 2030 Agenda for Sustainable Development that's explicitly mentioned. There could be chemicals, whatever, but no, it's marine debris. And in the recently concluded United Nations Environmental Assembly in Kenya, 22 of the resolutions that are dealing with substance, with content, 10 of them dealt with plastic in the environment. I think, to be honest, I like this topic, but it's a lot. And who can even read all of them? I mean, it's quite a lot. So just coming back to focus a bit my presentation now, there are three major sources of marine debris when we look at sea-based sources. One is shipping, so operational waste, cargo. Then the second one is fisheries, ghost nets that are lost, discarded, abandoned in the environment, aquaculture, dolly ropes, so really those things that protect the nets, they lose some fibers. And the third one is dumping. Even though the dumping regime is quite advanced with regard to plastics, there are several pathways. For example, the sewage that we bring out into the sea contains microfibers from our washing and personal hygiene activities. So this is a pathway that is important, but I will not address today. And what do we know? Yes, okay, so a lot of people know, of course, this cute little seal entangled in nets. Over 1 million seabirds die at least in the EU each year. This is what is estimation. You know, it's very difficult to estimate that. We know that marine debris has huge socioeconomic impacts. You see the boat, it has impacts on tourism, on ecosystems. The marine debris can really smother seabeds. The coral reefs in Australia are affected. And then we come to my favorite topic, ingestion. And you see here 2 whales, and they've been stranded not far away from Hamburg last year, 2016. And one of them had 13 meters of fishing nets in his belly. Then he had a piece of a Ford, may I say that? A car piece, the entire front of a car. He ingested it, buckets, and at least 25 kilo of other different type of marine debris. So right at the doorstep of Germany. It's at the beach in Germany. And then the right picture on your right top, this beautiful neon colors. This is where it gets exciting because this is the potential human dimension of marine debris. The little neon colors that you see are little microplastics that are found in the muscles of a blue mussel. I hope no one ate a blue mussel in the last couple of days. So this is actually done from the North Sea. This mussel has just like a sponge sampled or digested the water and has therefore taken up microplastics. This is a dimension that needs more and is currently really heavily researched, but it might be a human dimension, this topic, and there are yet a lot of uncertainties whether and how far this is impacting us right now. So there are some, I would like to just outline some knowledge gaps because any, again, environmental lawyer has to look at the scientific side. We cannot just do law by law. We need to understand what are the scientific community, what are they struggling with. First off, we know that dumping might be a source. There might be even more than the microfibers. The paints used on ships and the cleaning of ships. Ship recycling could be a source, but I mean, it's not even considered as marine debris, but of course it can be part of marine debris. And the offshore community industry, meaning oil platform, these kind of things, there are no information whether they are a source of marine debris from seabed source. Then also the fate of marine litter. How long does it stay in the ocean? Approximately a little bottle, that it's 450 years that stays in the ocean. And I would argue that we need to know the fate of marine litter, because then we can move from a risk-based approach to understanding which items we need to target first, because they stay the longest in the ocean. We do not know quantities, how much litter enters the ocean. We have some modeling from land-based, but sea-based, no, I don't know. Maybe Anna Boboremai knows more about that, but as far as I know, there is not really some really confirmed knowledge about that. And of course, the impacts. This will be long-term. If we know that one little bottle stays with us for 450 years, we have to somehow arrange humankind with plastic that we have in the sea. Then moving on to the legal regime, the starting point is the 2030 agenda says we would like to prevent and reduce marine debris, but reduce by how much? If we do not even know how much pollution load we have in there. 1990, 2000, 2010, where should be our baseline? What would we like to achieve? Where should we start? And then overcoming fragmentation, I think it's a theme that we had so far. It's inherent in the UNCLOS that we have a very sort of separate approach to the different sources of pollution, and this is why it's quite hindering to have effective solutions for this problem. And then, of course, managing the diverse set of stakeholders that we need to have: waste management, tourism, fisheries, chemical people, just normal people. So it's quite complex. And enforcement, which we also learned as well. How do you figure out that a ship crew threw bags of plastic overboard if there are several thousand on the way? And I love when people say, "Oh, marine debris is an emerging regime." I like that, because it's not. I mean, I'm not a graphic designer, so please excuse me. With Professor Schierkop and Ringboom, you have more beautiful timelines, but this is just an outline of when we first have an understanding what the issue, that the marine debris is an issue. So in the 1960s, the United States government already outlined that it could be a problem. Then in the 70s, the London Convention that deals with dumping, and also plastic was part of that, has started already outlining that this is an issue. Then we have the CBD, there's also some work on plastic, Rio Declaration, the MARPOL convention that deals with garbage. In this case, I will talk about that later as well, was adopted in the 1980s. And it explicitly deals with garbage. So there must have been an awareness that this issue is an issue. And it's just mind-boggling why it's taken us such a long time, and we still haven't moved further in our effectiveness or in the protection regime. So we know there's awareness, we know it has impacts, and my question is, why has nothing changed? And I would like to outline now the legal framework, and I say that with regard to shipping, a lot of things have already changed. So the fundamental approach, if we look at waste from shipping, is the Annex 5 of the MARPOL Convention. And it's an optional annex, so it means that states have to ratify it outside of the normal annexes associated with MARPOL. And it's a very successful annex. 153 countries have ratified it. It has 99.38% of the world gross tonnage are bound by this, so it's quite a successful annex, actually. So it means there's a lot of willingness, at least, to comply. And in 2011, this annex was revised, so it's quite a new starting point for shipping. And I would just quickly outline the 5 pillars on which MARPOL Annex 5 is based, and what this is essentially the pillars of the protection regime that we're looking at with marine debris. The first and most important one is the discharge standard. Overall, the new revised MARPOL Annex 5 has a general discharge prohibition, which is great. And it also includes a definition on plastics, on garbage overall, and on fishing gear, which is quite exciting. So there's no excuse anymore to say, oh, I didn't know. Is this plastic or is this garbage? I didn't know that, so that's quite great. Then there are discharge standards outside and inside special areas. So again, like in the other MARPOL annexes, there are special areas that are noteworthy of protection. There you have higher discharge standards, and also you need to have adequate port reception facilities in place. So then the ships have an obligation, but also the port have an obligation to receive these the garbage. And then there is the port reception facilities I will talk about later a bit more. Then the operational requirements, so the crew on board, they need to make a dedicated garbage storage place, they have operational board, they need to have an information what can be thrown out and so forth. And then the fifth pillar is port state control. We learned it yesterday, that's about enforcement. And there are provisions as well how MAPA Annex 5 can be enforced. And just coming now to a bit more specific issues. I would say it's very positive that the new MAPA Annex 5 has now a definition of garbage, including plastic and fishing gear. And what I love is that fishing gear is included now in MAPA Annex 5. So that's quite an unusual thing if you know that fishing is regulated by the FAO usually. So I think it's quite an ingenious hack to somehow create an obligation to report the lost fishing gear to the flag state and in the coastal state, where if you lost it in a coastal state. However, can anyone guess how much fishing gear loss has been reported so far? No, unfortunately not, one. So yeah. So let me put it this way, it's not very successful in that way. So things have to change, maybe. Then something very negative, I would say, is that there is no legally binding obligation to deliver the waste in the port. It's part of the MEPC guideline, but it's not legally binding. It doesn't say it sort of from the outset. And this is something where I would say, I would have argued differently. Now, coming to the adequacy of port reception facilities, like I said, it's a very important element of the MAPA Annex 5. It says that adequate means that the facilities can receive all the waste of the vessels that usually call on these ports. And the second thing is without undue delay. And this is where it comes back from the Professor Schierkopf's outline with regard to just in time. The crews do not want to waste time to wait for maybe a truck to receive their waste. It's a really important aspect. And I would argue that the definition and the guidelines that have been developed at IMO are too vague, and they are actually really a weakness in the regime. And the second one is that I see it yin and yang, Professor Schierkopf said it as well, port and ships, and so far MAPA Annex 5 has been always quite focused on the obligation for ships. However, they have to have garbage management plans and so forth, but the same doesn't apply to ports. So there has been some stories from crew members where they had separated the waste in the ship, but then they went to the port and they just had to throw it into one big container. So this is really undermining also the efforts that are done on board. And there are some MAPA guidelines that further substantiate it, but they really do not give a lot of concrete guidance. And luckily, the MAPA Annex 5 are minimum standards, and we can, the obligations can be further substantiated. And I have opted now not to choose the EU. I mean, the EU will be front runner, and Anna Bobo-Remain will talk about that later. But I've opted to talk about the really great regime that is established by the Helsinki Convention. And the Helsinki Convention is the convention that governs the Baltic Sea. So from the eastern part, Kiel is, for example, a city that's bordering the Baltic Sea. This is a special area under MAPA Annex 5, so it means it's already understood that this area needs more protection. And the Helsinki Convention, the contracting states have a really pioneering role in addressing ship-based waste. They have done it through a coordinated approach. There's a mandatory delivery of waste in ports. It's legally binding. And they have also developed strategies on port reception facilities, how to organize it with costs. And they have also, most prominently, developed the no special fee system, and Mrs. Reiling talked about it yesterday. It's the flat fee, the indirect fee, meaning that you can deliver your waste free of charge and it's included in the harbor fee. There are, of course, associated aspects to this. So first of all, it's an economic incentive. And the idea is to harmonize it in the Baltic Sea and in the North Sea as well. And some ports do that already in the North Sea and in the Baltic Sea. It's quite a successful element. And there are some further definitions. For example, if there's green ship criteria could be in theory applied. So you could have a green ship that comes in the port and they have maybe waste management, but there is no certificate, there is no standard yet. So it's really difficult what we understand, or what the port administration should understand as a green ship. And of course, the role of the polluter pays principle and the cost recovery in this aspect is quite difficult, because the ship is a polluter in that they produce waste, they bring it to the port, and they can get rid of it for free in a way, because they don't have to pay directly for it. So these are there needs to be some more work to be done on how to substantiate that. And I think that in the EU there's a lot of work being undertaken with the adoption, hopefully, of next week of the new PRF directive. And now we come to enforcement. So we just had the incentive approach from the Helsinki Convention, and now we had the enforcement. And before I joined the WMU, I worked for the German Environment Agency, and we organized the OSPA-HELCOM workshop on sanction and fines of infringements with MAPA Annex 5. So we had port state control officers, waterways police, port, ship owners there, and we all discussed these kind of things. And overall, the challenges were that it's very difficult to detect plastics. How do you detect it with oil? You can at least sort of have an aerial overview, you can see it. But however, with plastic, you cannot do it. It's sub-threshold. A bag of plastic maybe doesn't kill someone or a bird, but in the cumulative effect, it's really heavy. Then the port state control officers or the waterway police here in Hamburg, they said, we go on the vessel and we have to do ILO standards, SOLAR standards. We are inundated with the pressure. We go on there, and even though we would like to look at it, plastic is the least concerns if we know that these people on board are not safe, because there are some really big issues on board, and we need to have more training on this. And then also there is a lot of different communications between port inspectors and port authorities. So this is a rule of research that has to be more undertaken. And then there's something I would like to talk about as well. It's been mentioned quite a lot of times in the different work on marine debris, is that why don't we just have really heavy fines for those people that are infringed with MAPA Annex 5 obligations? And I'm sorry, I just took the German Hydrographic Agency's information. It's not that Germany is the only country that has these numbers, but it's just really readily available. So in 2015, the 580 deficiencies with regard to MAPA Annex 5 were found, and the total sum of 18,248 euros were fined. And I did the little calculation, it's 31 euros per fine. So I'm not so sure whether this is actually a deterrent thing or not. Like I said, it's not only Germany, other countries do not even disclose this information. So I don't want to discredit my own country, but I just wanted to outline that maybe something has to be done in this regard. And this leads maybe to a research question whether administrative fees would be more interesting in moving forward with this. Then the Paris MOU, this is what Ms. Reiling already talked about yesterday as well. They had 469 deficiencies. Out of them 12 were detainable deficiencies, so they were considered as heavily enough to detain a ship. So that's quite interesting, actually. And because I like to do these kind of things, I look at the Paris MOU is caught in the net. It's not a sort of like a sort of very strict thing. It's port state control inspectors can write a little comical, it's really funny sometimes, a piece of ships. They really made a good impression on them because their deficiencies and their mistakes were so high. So this is a ship, Fetisal, from Congo, flying the flag of Congo, and that was detained in Greece in 2016. And don't go down the rabbit hole reading down Caught in the Net. It's actually quite funny. So when I read it, I found that, for example, here it's just one. They had a MAPOL infringement or deficiency. That they said that the placards were missing from the storage site, so no one really knew where to put the garbage. Because there was no picture, I went to a different example, and I found this. So imagine this is on your deck, and there's wind, storm, water, whatever. Then of course these things fly overboard. So this is one example of what could be a deficiency, for example. I'm not so sure if that could be a reason for to detain a ship, but this is something that's an example just to clarify what something like an infringement could look like. And then I just discussed that we have so many different aspects with regard to sources of marine debris, and the regional seas agreements in the Baltic Sea and in the North Sea Atlantic, the OSPAR Convention, the Helsinki Convention, are front runners in this. They have adopted the regional action plans on marine debris that are based, all of them, on 4 pillars: land-based action, sea-based action, cleanup efforts, and awareness raising. And they have all addressed the issue of sea-based sources. They have harmonized PRF systems, so what I said, they really try to push forward that now. They look at enforcement, best practice at fishing industry, and fines for littering at sea. So this is something that they are pushing as well in their own little means, but it's of course only the marine environmental protection community. And to make it a bit more complicated, we have the G7 and G20 action plans on marine debris that were developed both by Germany and that were modeled after the Helsinki and OSPAR Regional Sea Action Plan. So we have here, this one is from 2015, the G7 German action plan on marine debris, and then we have the G20 action plan on marine debris. So yet another action plan and yet another more information. And then to make it worse, the Italian presidency picked up on this, and the Japanese presidency picked up on this, and I know that the G20 presidency in Japan will pick up on marine debris again. So we'll have yet another layer of information of actions that are coming our way. But there are good news. The International Maritime Organization has adopted in October last year an action plan on marine debris. And I will not go into detail, it's based on 8 pillars. But what I would like to outline is that, in essence, it really picks up on those things that were deficient in the system, really trying to work the different gaps that are known. And I would like to now talk quickly about the regulatory framework, because there are some lawyers in the room, I heard, and then also the effectiveness of PRF. And for example, I mean, the wording is respectfully quite weak, but there are now efforts underway to work further on how to strengthen the role of ports in the separation of waste, and then also how to enhance enforcement of MAPA Annex 5, and then also the cost framework associated with port reception facilities. So really working on the lines of how do we subsidize, how do you compensate the waste that can be landed for free in the harbor. And then the last one that I'd like to mention is there will be work coming up that will develop a regulatory framework matrix for the purpose of a gap analysis. If you ask me, there is already enough understanding what the gaps are, but I think it's a good first step also for the legal research community to move forward and to give some substantiation also, for example, from administrative law. These kind of different aspects have to be involved. Just a short outlook. The World Economic Forum has outlined that by 2050 we'll have the same amount of plastic than fish in the oceans, so that if we continue with our business as usual, so it means we need to start doing something. And there are 5 main areas where I think things will move forward. It's first of all marine debris in the new agreement addressing biodiversity beyond national jurisdiction. In the IGC that just ended this week, there were at least 12 states that mentioned explicitly marine debris. They talked about pollution, but they meant marine debris. So it's already high on the agenda there. Then we know that marine pollution is a reverse strategy of the commons. We do not take something out, we throw a lot of things in. And what this does to our commons, we'll have to see about that. Then addressing the issue with plastics, Germany and other countries are pushing hard towards the International Convention on Plastics that would address the entire global value chain of plastics. And it has not been very successful, I would say, but I guess shipping has to be part of this one. This will be coming ahead as well. And the role of the IMO and the green shipping concept, or the sort of move towards zero emission with regard to garbage, this is something where IMO will have to work a lot as well. And then, of course, the regulatory framework relating to cleanup efforts, liability and compensation of damages relating to marine debris will be as well part of the work. Just to conclude, shipping has quite a relatively high protection standards with regard to marine litter, but there's further substantiated needed, and we know that enforcement must be strengthened, but I would argue that incentives, the role of incentives and really trying to make a business case out of it, giving waste a value, this is the way forward. And there's a lot of research to be done, both from the legal community, but also from a lot of other fields. And the responsibility of states to address the global value chain will be probably the way forward when we want to talk about it. Thank you very much.
Very much for your talk. I'm sure there will be many questions. So again, my request to the audience, keep your questions in mind, write them down, type them into the webinar so that after our last talk for this panel, we can have our discussion. Our last speaker for the morning session is Anna Bobo-Remain. She is working for the European Commission. I should emphasize, she's a lawyer as well, so because Alike just mentioned there are some lawyers in the room, there are many lawyers in the room. Anna is one of them. She has 2 LLM degrees from Leiden and from Leuven University. She's been working for the Commission for a long time. She has worked for different departments, for the environmental department. She has worked for the European Maritime Safety Agency, and since 2012, she's a policy officer in the Directorate General on Mobility and Transport, where she's responsible for primarily for a port reception facility. So this will now we move on from the overview and the different aspects of marine litter from land-based sources and on the sea to responsible responses to deal with such litter imports and the role of the EU in this context. So, Anna, we're looking forward to your presentation.
Yes, good morning to you all. Thank you for the nice introduction, and thank you very much for inviting me to this conference. Again, it's a great honor for me to be here, and it also presents for me an excellent opportunity to present you new rules that were recently adopted. Well, the formal adoption will happen next week, the new directive on port reception facilities for delivery of waste from ships. So the main focus of my presentation will be on the PRF directive. If time permits, I will also say a few words about another directive on ship's pollution. It was already mentioned by Professor Ringboom yesterday, which also foresees the introduction of criminal penalties, which is also very relevant in the context of waste from ships. So I would first like to say a few things about the policy context we are looking at. There was an excellent presentation by the previous speaker, which already sets the scene, so that helps me very much in presenting the rules on ships as pollution, in particular waste from ships. When I'm talking about waste from ships, I'm talking about more than marine litter. It's all the waste as defined in the annexes of the MARPOL Convention, so the polluting substances falling under the different annexes of MARPOL. MARPOL Annex 1, oily waste, Annex 2, noxious liquid substances, Annex 4, sewage, 5, the garbage issue, where the marine litter problematics come in, and also MARPOL Annex 6 to a certain extent, where we're talking about residues from so-called scrubbers. So the 2 instruments I'll be speaking about today are mostly there to help implement and enforce the international rules provided in the MARPOL Convention. So I'm talking about the MARPOL regulatory context. The EU directives are forming part of the EU maritime policy, so they have a transport legal basis. At the same time, they're sharing the same objective as the MARPOL Convention, the prevention of pollution from ships, so they have an environmental objective. And in that sense, they're also instrumental for the application of EU environmental policy. So in particular, the waste and water legislation, the framework directives, which brings us back to the topic of marine litter, which has focused very strongly in the environmental policy in the last years. So the directives I'll be talking about today, I will focus on the directive on port reception facilities, and then, as I said, I would also like to say a few things about the directive on ship source pollution. So let us focus on the directive on port reception facilities. I have to say, adding a personal note, this has really been a long personal odyssey for me. I have been following this directive since I joined the European Maritime Safety Agency, which was back in 2005, where the colleagues were already talking about a revision of the current directive, which is Directive 2059. Which was considered out of date. There were inconsistencies in application, so there was a need to revise this. And then when I joined back the Commission in 2012, I was given this file with the request to start with an evaluation. So we did what is called a REFIT evaluation. We looked at the regulatory fitness of this piece of legislation, seeing if it was really still fit for purpose, has it been effective, etc. So we concluded this process. It clearly indicated there was a need for a legislative revision. The directive was no longer aligned with the MARPOL Convention. Member states were interpreting and implementing this directive in many different ways, so there was not a real level playing field in that sense between ports but also ships, which as a consequence meant the directive did not deliver to its full potential. And in order to start the legislative revision process, we had to do an impact assessment. So the impact assessment we did in 2017. I'll say a bit more about this process later. And we delivered a Commission proposal, we rather tabled a Commission proposal in January 2018 as part of the Commission Circular Economy package. And we then concluded negotiations at a super speed. So within 1 year, we managed to find agreement between the co-legislators. And we had this political agreement that we reached in December 2018. And I'm proud to say that next week, we are in the final stage of adoption. The Council is expected to adopt the directive, after which it can then be published in the official journal. Okay, that leads us to a new directive. And I will be going a little bit more into the details of this directive. It has, as its predecessor, because we should not forget we already have a directive in place, the 2059 EC, which is going to be repealed. It has a very large scope. So it includes all seagoing vessels, so from the very small recreational craft and fishing vessels to the large container ships and cruise passenger vessels. And also all the EU ports that are visited by those vessels. So again, these are very small marinas to large commercial ports like Hamburg and Antwerp that we talked about yesterday. It has a twofold objective, and now I'm talking about the new rules in place. It's still about reducing discharges of waste from ships into the marine environment. So it aims to do so through ensuring that adequate facilities are in place and that ships actually use those facilities. On the other side, it also should help to facilitate transport operations in ports by reducing administrative burden. And one of the overriding aims is the contribution to the circular economy. As I mentioned, we were part of the circular economy package issued by the Commission in January 2018. And let me say a few words about the links between the PRF directive and this circular economy package as we see it, is that the PRF directive is a very key instrument for addressing the sea-based sources of marine litter, which the previous speaker commented on. And this includes merchant ships, fishing vessels, recreational craft, all included in the directive. And during our impact assessment, the focus on marine litter became stronger. The PRF directive covers different types of waste. We tried to quantify the waste gap. So that is the contribution, the amount of waste discharges at sea. This was a very difficult exercise, as you can imagine. What we had was a set of data of how much waste was delivered in certain ports during a certain period. And we then also used a model to calculate how much waste was generated on board of the ships visiting those ports. By combining or comparing these, we calculated a waste gap. The waste gap being an indication of how much waste is illegally discharged at sea. And what we found during this assessment was that the waste gap was the largest for garbage waste, so for marine litter. up to 30% of what should have been delivered was not delivered in that 5-year period on the review. In addition to that, we undertook an environmental vulnerability assessment of the different sea areas in Europe, in European waters, the different sea basins, including the Baltic, but also the Mediterranean, the Black Sea, and the Atlantic. And what we concluded was that the environmental impacts, or also the vulnerability of these sea areas, was the largest when it came to garbage, so marine litter. So this also justified a specific focus of the Commission proposal addressing this issue of marine litter within MARPOL Annex 5, so the garbage. And we calculated that with the revision of the PRF directive as proposed by the Commission, we could reduce up to 300,000 tons of waste annually discharged at sea, and this is garbage waste. Then a few more words about this relationship between the PRF directive and the MARPOL Convention. During the impact assessment, it has been also a bit of a challenge to explain, including to the Regulatory Scrutiny Board, why we needed a PRF directive. Several times it was mentioned, we have the MARPOL Convention. Is that not sufficient? Do we really need EU rules? Again, we try to explain also in the impact assessment that we need this directive to help to strengthen the implementation and enforcement of the MARPOL provisions through EU law. And it was interesting to see Professor Ringbaum's schedule yesterday of where we are with the PRF directive in the scale on what we add to the international framework. Indeed, the first aim is to help putting these norms into EU law, to help with the enforcement. But there are certainly elements which are in non-legally binding instruments which through the EU directive are made mandatory. And there is a number of instruments which are mentioned here. The waste reception and handling plans which are required under the directive, advanced waste notification. I will say more about these different instruments later. Cost recovery, etc. These are already included in IMO circulars and guidelines, but through the EU directive, they are made mandatory instruments to be applied in EU ports. In addition, the directive also complements MARPOL by, for instance, foreseeing an extensive regime on inspections, on enforcement, and also the electronic reporting and information through electronic systems which are operated by the Maritime Safety Agency. And it kind of translates the MARPOL discharge norms in a delivery obligation. So these are things which are complementary to the MARPOL regime. So let us now go a bit into the specific provisions which are new to this directive. So we have 3 main sections in the new directive, and there you very much see the reflection of the distribution of responsibilities. So there are obligations both on ports on the one side to make sure that the facilities are available and adequate to receive the waste, and there are the obligations on ships to make sure that they actually deliver their waste on land instead of discharging this at sea. And this is then achieved through economic incentives, enforcement, and there are certain exemptions also foreseen in order to facilitate maritime transport. And then there's a number of administrative provisions as well, which is part of the 3rd section. So first focusing on the adequacy of the facilities. So as the previous speaker said, this is already required in the MARPOL Convention that the states have to make sure that there are adequate port reception facilities available. The adequacy as such is not very clearly defined, certainly not in the current directive. We try to clarify this more, putting into law certain elements from the PRF guidelines. There are very, very detailed guidelines from the IMO on what is on the operation of port reception facilities, some of the elements which you will now also find in the PRF directive. This distinguishes both between the operational conditions, so are these facilities, are they easy to use, are they well located, etc., and on the other side, the environmental operation of those facilities. So are they operated in accordance with the principles of environmentally sound management of waste? And in particular here, and it was mentioned in the previous presentation, that there was some frustration by ship owners that they were following international norms, segregating the waste on board, and then they would come into port, and everything would be dumped into one container, which obviously is one of the things to be avoided. So we provided a specific requirement in the new directive for separate collection of the waste that is delivered. I have to add, in accordance with EU environmental law. So this is where, again, the links with the EU waste legislation comes in, where the separate collection is not always that clear. There's a wide margin of discretion for member states. I would also like to just add here, because yesterday the Commission was a bit criticized by one of the speakers for not consulting between the different directorates. I have to say I worked in very, very close cooperation with my colleagues in DG Environment, in particular in the waste unit, but also DG Mare, who was busy with the fisheries control regulation and changes to the fisheries control, to make sure that anything that ends up in our directive is fully consistent with what they have put on the table. And in particular, I would like to mention the Single-Use Plastics Directive, which also covers fishing gear, which is also going to be adopted very soon. So we worked in close cooperation in order that we hope there will be enough legal clarity in the future and not felt that there are great inconsistencies between these pieces of legislation. In addition, when we come about the adequacy of the facilities, it's worth mentioning that we have included new types of waste in the scope of the directive. So waste is defined as per the annexes of MARPOL. We have now also included MARPOL Annex 6 waste, so these are the residues from scrubbers, particular scrubbers which are operated in closed loop mode. They have certain residue sludge which needs to be delivered in port. And also a new category of waste which is called passively fished waste. So fishermen, when they go out at sea, they collect also waste in their fishing nets, which we want to avoid that they throw back at sea because they're going to be penalized for bringing this into port, so they will have to pay for this. So we have also included this particular waste in the scope of the directive, which means that ports in the member states will have to make sure, that the facilities are also capable of receiving the passively fished waste. Then I talked about the application of EU waste legislation, and also to ensure that these facilities are adequate, the waste reception and handling plans which are required by the directive to us are one of the main instruments to achieve adequacy. They have to be developed in close consultation with the port users, so this also includes the clients of the port, the ships that are visiting, but also the operators, local communities, NGOs, so all of these parties will have to be involved when these plans are developed. The plans will have to be continually assessed and re-adopted, in particular when significant changes take place in the operation of the port, and that is also a concept we have tried to define better. So moving now from the ports to the ships and what the ships need to ensure under the new directive. So as I said, the MARPOL discharge norms have been in a way translated in a delivery obligation, something also the previous speaker mentioned that is very important. It's easier to control also whether a ship delivers into port rather than enforcing the discharge norms at sea. And how do we make sure that ships deliver? There we have used a bit the carrot and the stick approach. On the one side, to make sure that the financial incentives for delivery are in place. And then we're talking about the famous cost recovery systems, which we already have under the current directive. They are based on the polluter pays principle, making sure that the costs of PRF are covered through a fee from ship. That is the basic principle. I have to say, this was the most debated article during the negotiations, clearly because it's about money, so you can imagine both the ships and ports being in arms and member states as well. So this has been a very difficult negotiation. In the end, what we have ended up with in terms of changes to this article is that we wanted to create more transparency between the fees and the costs. So if a ship pays a fee, it wants to know what this fee is being used for. For that, we have included a new annex which sets out the costs and the revenues that need to be covered by the fee that is charged. And this is again where the links to the future Single-Use Plastics Directive come in, because in the annex we also mention the revenues from extended producer responsibility schemes. So in a way, when you look at the polluter pays principle, it's not only the ship which carries responsibility, It's also the producer of the goods which are used on board of the ships and which then become waste, which carry responsibility. So these revenues will also need to be taken into consideration. We have tried to harmonize the calculation method of significant contribution, because one of the other principles in this directive is, in order to create an incentive, part of the fee needs to be an indirect fee. An indirect fee, as was explained yesterday, is a kind of flat fee. It has to be paid irrespective of delivery, meaning that a ship would not have to gain anything by discharging in the sea and can just as well deliver, because they have to pay the fee in any case. For most waste types, this is partly indirect fee, so it will be 30%. But for garbage, marine litter, given the focus of our proposal on this particular waste, we said we have to be more ambitious. And we make this fee not, or this part of the significant contribution, not 30%, but what 100%. Now, what does this mean in practice? It means that when a ship has paid its waste fee when it comes into port, it has a right to deliver all its garbage. So without having to pay additional direct fees based on volumes that are delivered. Because in the Commission's view, it was always, as soon as you have a fee which is based on volumes delivered, it's always an incentive for ships to get rid of the waste in a different way. We have also included the passively fished waste in this 100% indirect fee for garbage. And I should also note that the old and derelict fishing gear is included here because it is falling on the MARPOL Annex 5. We have also included the fishing vessels and recreational craft in the application of an indirect fee system, which was not the case up until now. They were excluded, so they would have to pay direct fees. Then there is still the possibility for port member states to differentiate the fee based on the type of ship, the size of the ship, etc., but also looking at, for instance, the type of traffic that the ship is engaged in. For instance, ships in short sea shipping should get a mandatory reduction, and also ships which can be considered green ships. Now, this green ship concept in the context of the directive will still need to be developed through an implementing act. This will be a very challenging task because there are many aspects to what can be considered a green ship. The basis is already provided in the new directive, which in the context of the directive, this is a ship which makes special efforts to reduce the waste generated on board or treats the waste in an environmentally sound manner. So this will be our starting point. But we will certainly be looking with the experts now at how to define these conditions for recognizing such a ship so that we will have a harmonized standard to be applied in all ports, in all EU ports where the ships are calling. And this will be a mandatory scheme, which was a bit of a difficult issue for the ports during negotiations. Let us now look at the other side, the enforcement side. As I said, there is a mandatory delivery requirement, which is a fundamental part of this directive. We have tried to define the scope of the mandatory delivery more clearly in accordance with MARPOL, because the current directive was saying ships should deliver all their waste when they're in ports. And strictly speaking, this would also apply to waste which normally can be discharged on the MARPOL, such as sewage. Now, member states in reality were not implementing the directive in this way. They were implementing the MARPOL Convention. So sewage, for instance, was very often not included in this mandatory delivery or in the fee systems as such. To make things clearer, and one of the aims of this directive is really to find further alignment with the MARPOL Convention, is that we have to make it clear that this is in accordance with MARPOL. So we are really translating the MARPOL discharge norms into this delivery obligation. There is a whole system of reporting before a ship calls into port through the advanced waste notification. This provides basic information to help the port prepare the waste management process, but also has the important information that is the basis for the monitoring and enforcement, namely how much the ship is going to deliver, how much storage capacity it still has on board, which is the main exception to the mandatory delivery requirement. This information has to be reported electronically into a member state's system called SafeSeaNet, which is operated by the European Maritime Safety Agency. And one new element that the directive has introduced is a waste receipt. So as soon as a ship is delivered, it will also receive a waste delivery receipt, which will actually state the real volumes of waste delivered. By comparing these two sets of information will help to the authorities to conduct the necessary inspections, namely to focus on those ships which have not delivered and which there's a risk that they may discharge or that they will not have sufficient storage capacity until the next port of call. So all this information is basic for having an effective enforcement regime, which can be port state control, but it will be a dedicated inspection regime, so that port state control offices may be used for those inspections, but in principle it's a dedicated PRF regime, which will also be based on what we call a union risk-based targeting mechanism. This is something that will be developed together with EMSA, also again through an implementing act, and which will be the basis for having risk-based approach for inspection. So what we really try to do here is to make these inspections as effective as possible, but also efficient. So not to overburden ships which have complied with the delivery norm with unnecessary inspections. There are certain exemptions in place, as the current directive also has them, for ships in scheduled traffic with regular, frequent and regular port calls, the ferries, etc. The difference with the current directive is that we have tried to make it very clear what we mean with those ships. So we have definitions of what are ships in scheduled traffic. We have also made it very clear that there needs to be an evidence of an arrangement for delivery and payment in a port along the ship's route, so that we avoid situations where these ships are not paying or delivering their waste anywhere. They're completely outside the monitoring regime. We have also come up with a standard exemption certificate, which is a new Annex 5, the information of which will also be reported in this electronic information system, which will then also help with the monitoring of these ships, that they actually comply with their delivery requirements, which also exist. So just a quick overview on the adoption and implementation timeline for this directive. So as I mentioned, the European Parliament already adopted the text as it is on the 13th of March, and the Council's adoption is foreseen on the 9th of April, so very soon. And then this text will enter into force 20 days after its publication, which we hope will still be May of this year. The Commission is already very active in starting all the work on the necessary implementing acts. There will be 4 implementing acts that will need to be developed, as I already mentioned. One on the harmonized method for calculating sufficient storage capacity, which is one of the exceptions to the mandatory delivery requirements. Criteria for the green ships concept, where we will be organizing workshops also with member state experts, because this will, as I said, be a very challenging concept to define the criteria and conditions. With EMSA, we'll be working out the union risk-based targeting mechanism, which will be the basis for the risk-based approach for inspections. And then the European Parliament, during negotiations, has been very, very active. We had the Environment Committee associated with this file. So the lead committee was Transport, but there was also the Environment Committee, and they were really pushing for a lot of environmental measures to be strengthened through this directive. The main things I would say that they got out of the negotiations was a mandatory green ship concept, and the other thing was the inclusion of passively fished waste, and also an obligation on member states to report on how much passively fished waste was collected in ports, and also to report this information to the Commission. So this is another thing we'll need to work out through an implementing act, is to develop a methodology for reporting of passively fished waste. This again to strengthen the marine litter aspect, or this instrument as a way of addressing the problem of marine litter. And if I may come back on that last point, and something I didn't mention when I talked about the impact assessment, we know indeed there is generally accepted 80% land-based, 20% sea-based sources. Through our impact assessment, we found that in some of the sea bases in Europe, there is a much larger contribution from sea-based sources to the problem of marine litter, especially around fisheries and fishing gear. And that this is much more up to even 40 to 50% of all the contributions to the problem of marine litter. So this is really something to be taken very seriously, and as with the emissions, there's something that shipping can do, and that should not be left out of the equation simply because it's a minority of the contributions. So in the remaining 3 minutes, I would like to say a few words about Directive 2005/35 EC, which also partly falls on the responsibility of my DG. This is the Directive on Ship source pollution and the introduction of penalties, including criminal penalties for pollution offenses. Together with the PRF directive, this is one of the main instruments for transposing the MARPOL discharge norms into EU law. In particular, MARPOL Annexes 1 and 2, which is oily waste and noxious liquid substances. It has a kind of twofold objective as well. So on the one side, it's to help strengthen and enforce these discharge norms through EU law. On the other side, to ensure that those responsible are subject to adequate penalties, including criminal penalties. It has a very wide scope, so discharges from the internal waters to the high seas, again within these jurisdictional boundaries set by UNCLOS, which Professor Ringboom commented on yesterday. It was amended by Directive 2009/123 EC to strengthen the criminal law aspects. This directive replaced the Council Framework Decision from 2005, which is annulled by the Court of Justice, and introduced the criminal law aspects into the legal framework. In particular, the changes through this amending directive made it clear that illicit discharges from ships are to be considered criminal offenses when they are committed with intent, recklessly, or with serious negligence. And these result in the deterioration of the quality of the water. So minor offenses are not considered criminal acts unless a series of minor incidents together deteriorate the quality of the waters, then they can still be considered criminal. This amending directive also puts in place the provisions on liability of natural and legal persons. There is a whole framework on how this should be monitored and enforced. There are certain enforcement measures, some that are based on port state jurisdiction, so when a ship is in port. Others, coastal state jurisdiction, in particular in terms of ships in transit. And there's a whole system of collaboration in these inspections, but also information exchange. And here EMSA has a crucial role because EMSA is operating the so-called Clean CNET system, which helps to identify and monitor illegal discharges of waste through provision of satellite images to member states, which then have to follow up through aerial surveillance. We have stepped up our efforts on this directive because there is a lot of regional coordination between member states and trying to harmonize their approaches to monitoring illegal or pollution offenses. During the negotiations on the PRF directive, in particular, the European Parliament wanted to also focus on discharge prohibitions in EU waters, where we maintained throughout the negotiations the line to say, no, the PRF directive is about delivery of waste, imports, and when we talk about enforcing the MARPOL discharge norms, we are more in the domain of Directive 2005/35, and consequently, there was a call from the European Parliament, from the particularly ENVI committee, to have changes to the 2005/35 directive through the PRF directive, namely by extending the scope of 2005/35 to also include MARPOL annexes 4, 5, and 6, so sewage, garbage, and residues from scrubbers. In the end, this didn't happen. However, there was a clear call from the co-legislators for the Commission to look into a possible extension of the scope of this directive. So this is one of the follow-up works that we will have to do, is to look at, we'll probably have to launch an impact assessment on a possible extension of the scope of this directive. Also when it comes to the criminalization of pollution offenses, including substances falling under these annexes. We'll have to do that in close cooperation with our colleagues in DG Just, because they are responsible for the amending directive on the criminal law aspects. And then, as a last point that I would like to mention, if I may, is that we are also working on a harmonized reporting of waste discharges detected and followed up by member states, so to understand better what is happening in the member states. This will also be a basis for our impact assessment. We also are in consultation with the colleagues in the IMO, responsible for the GISA system, because they are revising the reporting into GISA, so to make sure that the two are being developed in parallel. So this is another strain of action that we have really stepped up effort. So we are trying to focus a bit more on this directive and its role in addressing illegal discharges of waste from ships. Our timeline for this revision is 2019 to 2021. So as you can see, a lot of follow-up for the Commission in the coming year. So this topic will come back on our agenda from time to time, and we will be consulting with experts, with academics in this field. So we want to make this an all-inclusive collaborative effort. Thank you.
And I would like, does it work? No. I would like to thank, is this working? Oh yes, now it is. I would like to thank our speakers, not only for their very insightful, fruitful presentations, but also for the discipline in perfectly keeping the time. So I was surprised that all of you made references to, oh, if it's allowed a little more time. You were all perfectly in time, and you had, all of three of you had complex issues, and you shared a lot of your expertise with us. Now it's time for questions, also via the webinar or live questions. You will have realized that there are two common themes that already came up yesterday and that came up again. One is fragmentation, obviously. So this is an issue that doesn't let go. Fragmentation of legal regimes, of a global and regional divide, on substance, on dispute settlement. And from what I got from our last speaker in this panel is that but that's my personal opinion, rather see the EU as part of the solution here than a part of yet another regional regime, but that's my personal impression. The other common theme are knowledge gaps and uncertainty with regard to data, with regard to future developments, technologies. Again, the EU with a monitoring scheme being more part of an institutionalized solution here. The way we deal with uncertainties and with these knowledge gaps will have a profound impact on standard setting, either from the perspective of precaution, so substance, but I would say rather of the kind of standards, whether that's goal-oriented, as Alder has emphasized in his talk, versus technical standards. What gives certainty in this respect and what allows for innovation? And let me mention that 3 weeks ago we had a small workshop here in Hamburg founded by the German Research Foundation on shipping emissions, where those representatives of the classification societies and the ship owners said, but don't agree on technical standards. That would hamper any kind of innovation. Only go for goal-oriented. But still, if you talk to those who are developing technical innovation, they say, well, if there's not standards for the infrastructure, we will not even invent or innovate in a particular region. So this is, will be difficult to find a balance here, and that could also be part of our discussion. Without me monopolizing and exploiting, abusing my role as a moderator, the floor is yours, and I've already seen that Till Marcus has a question.
Yeah, thanks for your very interesting talks. I have a question to both ladies. I was wondering when I saw your presentations and how much energy and brain power and enforcement considerations and administrative power will go into controlling these waste management measures. And collecting data, etc. And there's so much energy going into that. And how far are we? And I didn't follow the discussion, to be honest, in preventing the production of all these plastics that we have to trace and carry, get back on land, or monitoring people to not throw it into the water. It's I heard in a radio documentary that the industry, the plastic industry, says, well, there's a lot of potential for replacing or substituting certain plastic products by just biodegradable products that would basically waste away in the seas. And but how far are we there? And are any of those considerations playing into the development of your legal measures?
Would you like to take more questions? We take a few more questions. Alexander is the next one on my list. Now all the hands go up.
Wow, I'll be short in order to... but also, 3 great presentations. Thank you so much. They were so well also interrelated. And I think without you, although you didn't interact in advance, I was very impressed. Of course, I'm saying this in order to increase pressure for the speakers of the third panel, right? So you have a wonderful model here. My question goes to, the first question goes to Aldo. Annex 6 of MARPOL contains, which one? Regulation 11.6, I think, which has to do with the applicability of the jurisdictional rules of the UNCLOS also to emissions. That is exactly what we discussed yesterday concerning port state jurisdiction, which means that Article 218 is probably, assumably, also applicable with regard to emissions from ships. My question is, does that also apply to greenhouse gas emissions, or is it only applicable with regard to traditional pollution from ships? And my second question, Aldo, is the EEDI, this index solution, do you think that's effective? I don't know, I'm just curious to find out. Thank you.
So I saw 4 arms coming up here. We will have one further question now from this middle. I have Markus Kotzer on the block as well, but I have one further question from the lady up there, and then we have some answers.
Thank you. Thank you very much for the presentations. Mine is perhaps a comment, but you know, you are free to comment about it as well, particularly the second speaker. When you were talking about marine debris, the focus of your presentation was mostly on the ships, but you did mention in passing land-based sources, and I come from a university which is along the coast, the Atlantic Ocean, in Ghana, and for us, land-based sources are perhaps a bigger problem than those from ships. And picking up on the point about fragmentation, which you mentioned, I think there has been quite a lot of fragmentation between the international obligations, i.e. MARPOL and IMO, and the national port state control, etc. But more importantly, there's a huge gap at the community level. What is being done to bridge that gap? Because often what we see when we try to engage at that level is a lot of communities feel that perhaps their cultural traditions are being challenged by some of these often international obligations which they feel are essentially being imposed on them. So how do we bridge that gap between the local as well as the international and national? Thank you.
Could we turn down these stage lights a tiny little bit because we can hardly see the audience? Oh yes, thank you. That's so much better. So please, maybe we start with Anna.
Is it on? Yeah. Okay. Yeah, just to come back to the first question on prevention, which of course should be our main priority. That is also well understood within the Commission, and that's also why the colleagues in DG Environment have been in parallel very, very busy since May last year in when they tabled their proposal on the single-use plastics and fishing gear, to focus which focuses very much on preventing this plastic waste to come into the marine environment in the first place. So this directive should also be adopted in April and will then also enter into force on a very similar timeline as the PRF directive, where this directive foresees a certain banning of plastic products on the market, in particular certain types of single-use plastics. Quite a wide range, and then there are consumption reduction targets which will come into play. There is marketing or labeling of certain products to increase awareness raising, and importantly, there's also provisions for extended producer responsibility obligations and schemes, which will cover a wide range of single-use plastics, but also fishing gear. So with that, a large part, I mean, the Single-Use Plastics Directive covers about 80% of all plastic products found on beaches. So that will really have a huge impact. And in order to make sure that the links between single-use plastics and PRF are in place and respected, we worked very hard in the context of Article 8 to have references to the extended producer responsibility schemes in Annex 4. So the whole idea is that when a port sets its fees, it takes into account the revenues from these extended producer responsibility schemes. For that, it will need to get into consultation with national organizations on extended producer, or the producer organizations, which we hope can be done in the context of the waste reception and handling plans. So when these plans are being developed, they have to enter, or the authorities have to enter into consultation with all the relevant stakeholders, which includes also the representatives of waste management schemes. And this partly also comes back to the last question, how to involve the communities and to make sure that this is not just a top-down exercise, but they feel that they're also heard. From the PRF perspective, we think there's a good role there for the waste reception and handling plans to make sure that they are developed in wide consultation with stakeholders. Thank you.
I would like to address the question from the lady from Ghana. I think that's a really relevant question, particularly because international law doesn't help us really with land-based sources of marine litter. It's quite a toothless tiger. But there have been quite a lot of initiatives taken in the last couple of years to try to compensate for that. For example, under the United Nations Environment Programme, the Global Program on Action on Land-Based Sources, sorry, it's a very long name, there's the Global Partnership on Marine Litter has been established. And that's really focusing. There are municipalities, NGOs, stakeholders from different kind of the industry, states are on board, and they have developed quite a lot of guidance on how to move forward with that. So we can maybe meet up after, and I can guide you to that. And also what I know, Germany is not Ghana, but what we've done in Germany to address this issue is we have formed a round table on marine debris. I was part of administrating it before I joined WMU. We had over 180 different stakeholders on board that met every 3 to 4 months, addressing different things that were put on the table by the different stakeholders. So sea-based, the PRF directive was part of the discussion that we had. We even formed a position paper. So we had people from all kind of, we had small municipalities that really had a strong say because they said, it's us who has to deal with it. It's not you guys, the federal government of Germany. Listen to us. And it was a really fruitful and really beneficial discussion that we had. And I would like to also outline the role of the youth. Greta Thunberg, I don't know how to pronounce her name, the young Swedish lady that has really triggered so much change. I mean, I know a lot of people, it's quite controversial, but she has woken people up. So I think the role of youth, especially with this topic, is quite important, also with regard to creating a value for plastics, for creating innovation. Even in Ghana, I know that there are people that work with old tires to make something different, like to make shoes, for example. So there is a lot of innovation opportunity to overcome this really old model. So, but we can gladly talk about that.
Aldo, there were questions specifically. We have another microphone. Oh. So many mics.
I'm surrounded by microphones. Right, thank you, Alex. Do I understand your question concerning essentially port state inspections for GAGs and essentially the extent to which we can actually see those apply both under the umbrella, if you want, of UNCLOS as well as the maritime conventions? I think that's an excellent question, and it's not going to be easy. And ultimately, I think it depends on the measure, because there's such a broad range of measures we're talking about. And in addition to the measure, there might also be a question of consistency with other measures that have already been adopted that are subject to PSC inspections. So what do I mean by depending on the measure? Well, if we think in terms of the broad range of measures being considered, for example, for the short term, and one of the measures that has been discussed is the one that I mentioned concerning speed. But there is recognition out there it would be very difficult to monitor speed. How do you monitor speed at sea? And what is really slow speed as distinct from optimum speed? It really depends on the ship. So that is why if we are going to have that measure, I think the likelihood is it will be voluntary rather than mandatory. So we're going to see a package of measures here, some that can be inspected in port for compliance, others realistically we have to rely on compliance, essentially from the actors. And I noticed actually in the discussions that we've had generally, there was a lot of emphasis on enforcement. The shipping industry, of course, one would like rather to focus on compliance before enforcement for a broad range of reasons. But that's not the only one. Now, if we think in terms of, for instance, the EEDI and the SEMP, yes, these could be subject to port state control because they are essentially technical, they're quantifiable. With regards to the plan, for instance, that essentially there has to be a management plan on board. For instance, so if you don't have one on board, a port inspector will notice that. In the future, if we do go in the direction as, for instance, Germany and Belgium have just proposed for MEPC 74 to make the management plan compulsory for all ships, then essentially you're casting a broader net. But then let's say we do have a market-based measure, such as a carbon levy or cap and trade. What can you do with that with port state control? And indeed, there are bigger issues. Who would actually collect the levy? What would you do with the money? And so on. So there are a lot of unanswered questions there. I mentioned also there might be an issue of consistency here with other rules. So you all know that as of the 1st of January 2020, the sulfur rule will kick in, 0.5%, dropped from 3.5. Well, right, cleaner fuels is essentially what is expected, but the expectation is you will burn more of that fuel. Effectively, you're going to be producing more GHGs. And this is one of the issues that we have sometimes, consistency between expected outcomes of different regulations. I think we're going to learn a lot from what inspectors are going to be picking up with the sulfur rule. It will be really worth watching that to see what experiences we have for the future PSC inspections for compliance with GHG measures. And as to whether the EEDI is effective or not, well, of course, one would have to ask the engineers. I think there are people on both sides on this, but it's certainly being touted as one of the principal, I would say, short-term technical measures that could be ratcheted up. So essentially, we have different phases, and with gradual increase in the efficiency of ships, for new designs, in essence. And the idea here is to accelerate that, perhaps increase additional stages in the future to further enhance emission efficiencies. So there, let's put it this way, there is a lot of faith being put into the EEDI.
Yes, thank you. And just a few remarks. I know there are many questions. Thank you, Aldo, for pointing out, for making very clear in this context of legislation that we're dealing with, that all measures actually do have other and maybe unwanted effects, not only burning more of cleaner fossil fuels, but also in the context of sulfur, the reduction of emissions of sulfur aerosols into the atmosphere that have a shielding effect could actually increase global warming. Or at least scientists say it may be measurable when we now switch to 0.5. I'm also grateful for that you, in your presentation, broadened the arguments on reducing speed, because usually what we hear is just say, oh, then on-time delivery wouldn't work. There would be one disruption, and then on-time delivery, of course, would work. It would just take more, it would just take maybe 3 days more before things would arrive, but after that one disruption, you could again establish, that would be significant though, an on-time delivery, but you had other valid arguments here. I have now on my list, I have one gentleman from Pakistan, I have Suzette, I have Ivo, and I still have Marcus on my list. Please.
Presentations were very nice. I just want to ask one thing, that with the flat fee of for the ships coming in the port, the ships have an incentive to discharge. But at the same time, because it will be flat, they will be monitored and there will be incentives. So if they don't discharge, so how would you know whether the ship that has not discharged, whether that has not discharged because it wants to reduce the discharge, or whether it will go out and discharge somewhere else in the sea?
Yes, thank you. Suzette?
Thank you, Nila, for setting the stage of our discussion today. I do agree with you, the main theme that really connects all the presentations today, and thank you for all the presentations. It's really fragmentation of law and Aldo's wonderful regulatory legal pie of different areas of law that are really affecting the shipping industry, for example, really puts a very graphic picture to our discussion today. And I have two questions actually directed to Dr. Stephen O'Brien. First on lost cargo in the oceans. And I don't know, as far as I can understand from your presentation, as also as far as I'm from the regulatory framework of the IMO, lost cargo, of course, is not waste. But it's still, I don't know how significant is this a problem, and what do you think is the role of the IMO regarding this problem, and whether this would be also a something that should be part of the baseline, what kind of marine debris we really have there, how much, and we need to also include lost cargo. And my other question would be for Mrs. Remian. Thank you for also confirming that, of course, the EU Commission, the different directorates there, of course, interact with each other. And I've been, one of the things that I, from your presentation is this idea of indirect fee, for example, imposed on is it users, also the shipping industry. But I have a question on the plastic issue, for example, since we are talking also fragmentation. As far as I understand, the EU, the highest, with the chemicals exported to other countries, the EU is a producer of, one of the top producers of chemicals. The kind of chemicals exported to other countries are actually plastic. Yeah, chemicals that would be used for production of plastics in other countries, and this would somehow also directly, go into the question of our colleague from Ghana. So these are plastics that would. What are you actually at the EU Commission level? How do you deal with the issue with the fact that the EU is actually a top producer of plastics, and then we, on the other hand, we now have an incoming directorate on single-use plastics, banning this kind of plastics in the EU, which is really nice, I find, living here in the EU. But in other countries, we are also continuing to export this kind of plastics that we ban within our jurisdiction. So thank you for your answers.
Thank you. One last question by Ivo for this round, and then we have a round of answers and a last round of questions.
Yeah, thank you. Appel, University of Hamburg. I'm referring in particular to the speech of Professor Kirkhope, but it may refer to the other speeches too. You pointed out the importance of the principle of common but differentiated responsibility. In international law, this principle normally refers to certain states and their responsibilities. However, in the field of ship emissions, you have quite a lot of possible addressees of this principle. You have flag states, you have port states, you have coastal states, you have many different ports, you have ship owners and so on. So my question is, in the field of ship emissions, what does the principle refer to? And even more, can it be a meaningful principle at all? And the second question, you emphasized the tension between the evidence-based approach and precaution. That indeed is an important topic, not least in the relation between European and international law. So I would be interested in your assessment of the further discussion. Will activities justified with precaution on an international level only be successful if they are based on evidence, or do you see any other possible interpretation that may be successful?
Okay. Aldo, would you like to start?
Sure. Excellent questions, absolutely. Common but differentiated responsibilities. What does it actually apply to in essentially the discourse on greenhouse gas emissions? This was, as I mentioned in my presentation, very divisive because there was this, in my view, profound misunderstanding that essentially the principle could indeed be applied without producing fundamental problems with the way we regulate ships. As we've seen, essentially, international shipping regulation works because we develop conventions for universal application and then uniform application. So universality and uniformity are critical principles of maritime regulation, and indeed are reflected in the principles of maritime regulations. Now, the issue arose in parallel. It preceded the Paris Agreement, but during the run-up to the Paris Agreement, there was a group of states, basically, that essentially used the principle and felt that the IMO, in responding to the call to meet the Paris commitment, ought also to do so on the basis of the principles of the Paris Agreement, which included the principle of common but differentiated responsibility. Somehow the misunderstanding, in my view, was that there was some confusion in terms of no more favorable treatment for flags and non-discrimination between ships when they call imports, with common but differentiated responsibilities as a principle of international environmental law aimed really more broadly to the fulfillment of international environmental responsibilities. So that confusion lasted for quite a long time, and it really created a logjam. Eventually, it was sorted out, and you see space for both principles in this strategy, and with the understanding, really, that common but differentiated responsibilities in the context of GHG emissions really ought to relate to the building of capacities. The building of capacities for developing countries to be able to meet the requirements. But at the end of the day, we cannot really discriminate between ships because they fly different flags. At the end of the day, essentially, they're competing commercially, and they need a level playing field. Business needs a level playing field. So that's where we stand on it. I think that problem has been resolved. Fingers crossed. The other question related to the balance between the evidence-based approach and precaution. And indeed, to my mind, I still see some major issues between the two. And the evidence-based approach is actually a fundamental principle of maritime regulation. There is a resolution within the IMO specifically identifying 6 core principles for the drafting of regulations, and indeed one of them is precisely this. It's got to be evidence-based. In other words, there's got to be some science to support that a particular measure is going to help produce a solution. And indeed, that still holds. But the reality here is that the world of maritime regulation and international environmental law have increasingly weaved into each other. So I think it would be naive of us to think that there isn't a role for the precautionary approach, which, as we know now, is a principle of general international law. And indeed, there is room to argue, at least in my view, that given the uncertainty that we have with respect to essentially what measures will likely be the more effective, if you want, over the long term, because we're looking at a long time scale here for maritime regulation, we ought to be erring on essentially more essentially cautious approach in how we adopt measures and how early we adopt measures. And that is one reason why in the conclusion, in the end, I chose specifically to focus on, look, our understanding, our knowledge base has changed. The reality is that the Paris Agreement goals actually might not be ambitious enough. Given what we know now, we probably need something much more than what we've committed to in Paris. And that places a responsibility on the shipping industry as well, in my view. We're going to need a really robust set of measures for the short term, perhaps much more than member states of the IMO have been ready to concede to date. So that's where I see basically the balance between the evidence-based approach, but at the same time, we need to be more aggressive, more ambitious in the measures, given that what we think we know about the impacts of climate change essentially may already be outdated.
Thank you for the question with regard to the cargo. I will answer that. I think that's a quite relevant question. You know, I think you live in Bremen, so you know that there were recently several lost containers, and people were running to the shores of the East Frisian Islands collecting shoes and trying to find the other pair. So it is an issue. However, it has not been very prominent because there was a lot of focus on land-based, on ship-based sources from in the framework of MAPA Annex 5. But if you've seen from the MAPA IMO action plan, cargo will now be addressed under this one. So it is understood as an issue. I don't think that it has been explicitly dealt with it, and also it's not part of the traditional environmental regime. It's more about safety. It's actually, of course, loss at cargo. It has an economic value as well. So, and this, I think, might be easier for us to address this issue because there's, of course, an economic incentive not to lose these containers. So there is a lot of technical work going on now, how to ensure them with like monster waves and these kind of things. There's really interesting technical work and cooperation. So I think that it might be a bit cautiously argued easier to address that issue. And of course it needs to be part of a monitoring baseline. But in the end, it's marine debris. Marine debris is marine debris, whatever we find in there. So I think that I'm not so sure what the percentage of that is. But hopefully the actions under the IMO action plan will help us in trying to find more answers to these uncertainties and to this knowledge gap.
If you allow me, I would also like to come back very shortly on this issue of lost containers, because after this last accident we had in January in the Wadden Sea, my directorate was also asked to look into this issue and to see how it's currently regulated with the different instruments we have in place. So we did this analysis, and in the meantime, preparing the Marine Safety Committee in July, the IMO's Marine Safety Committee, we have submitted a union submission with a commenting paper. This is actually in relation to the IMO action plan, which was adopted by MEPC last year, which invited expressly member states to come forward with concrete proposals. So this commenting paper has a proposal for mandatory reporting of lost containers as a kind of first step. Why? Because there are very unreliable statistics at the moment. When we look into the figures, we cannot really see how many containers are lost annually. So it would probably improve the knowledge base. On the other side, by reporting, this would help facilitating the retrieval actions, because there will be more information on the location of these containers, which would then help to at least retrieve them as soon as possible. Not only they have an environmental impact, there's also a huge impact on navigational safety, and that's one of the reasons why this submission is going to Maritime Safety Committee. So just as a bit of a sideline, we are looking into this also in the Commission and quite active actually at the moment in doing something about it. We have also been part of this working room at IMO, at MEPC, on the action plan, marine litter from ships, where this issue of the lost containers is one of the priority actions, so that will certainly be taken forward. Now to come back to the question of the gentleman here from Pakistan. I understand your question more to be in relation to the enforcement. Even though you started referring to the incentives, it's more to make sure, how do you ensure that ships actually delivered? How can you check this? As I said in the presentation, but I couldn't go really into detail, but there's one important exception to this rule of mandatory delivery, and that is when a ship demonstrates that it has sufficient dedicated storage capacity on board until the next port of call. So if there's enough storage capacity, the ship is allowed to leave the port without delivery. However, to assess this and to calculate the storage capacity on board, this is quite complicated, as you can imagine. It's mostly left to the assessment of the master of the ships, but the authorities should also be checking this through the inspection regime. And this is why in the new directive we have come up with the proposal to have a waste receipt. So as soon as the ship delivers, it should be getting from the operators, the waste operators, a waste receipt, which states exactly how much was delivered. And that information that has to be electronically reported into a system, it's an electronic information and exchange system, can be compared to the information from the waste notification, and these are important sources of information to make an assessment of storage capacity on board. The idea is that, because we still need to also develop a union-based targeting mechanism where we can trigger certain alerts in the system to say, hey, this ship hasn't delivered in its last port of call. There is a risk that there isn't sufficient storage capacity to undertake the next journey. So the next port of call can be alerted to undertake an inspection. So this is to help with this, what I called risk-based approach to inspections. It will be done on basis of the information that is reported electronically by the ship.
Thank you. So I know that I'm now officially between you and your lunch, but I'm prepared to take 3 more questions. Marcus is on my list as a next.
Sorry, there was one more question.
Oh, I'm so sorry.
I'm sorry, I shall not take too much time in dominating this discussion, but there was a question on plastics. And I have to be a bit careful because then I'm stepping out of my domain in the plastic, which is organized also by other colleagues in the Commission. But as I mentioned, the PRF directive was part of the Commission's circular economy package. And part of this package was also a plastic strategy, which was also submitted at the same time, so in January last year. This plastic strategy looks at curbing litter, including the single-use plastics, port reception facilities. These were elements under that chapter of the plastic strategy, but it also looks at improving the recycling of plastic. So this plastic strategy has a number of elements and initiatives to move towards a truly circular economy by improving the economics of recycling. So it looks at when you produce and design a product already at the different stages of the product through consumption, but also when it becomes waste. So there are initiatives, for instance, to address the design of products to make sure that they will be easier to recycle. So there is a holistic view on how to develop this plastic strategy in Europe. And the single-use plastics is only one element of that strategy. Again, it's not my area of expertise, but I'm happy to share with you the plastic strategy. I can send it to you, and you will read how the EU is going to approach the different topics, including then the export of plastics, which should also respect these basic fundamental principles laid down in the plastic strategy.
Thank you. So we can take 2 or 3 more short. No, that's already too many. So I do have Markus Kotz on my list. We have one question here on the webinar, and we can take the last question from Eric. I apologize to the others who've just raised their hands and ask you to take this to the lunch break, provided that the questions now are relatively brief and ask for relatively brief answers.
Thank you very much. I just want to briefly come back to the question of fragmentations and regime collisions. Professor Kirchhoff has outlined that there is a wonderful convergence between the law of the sea, climate law, trade law, and so on. Of course, you could also describe it maybe as a collision, and my question would be, is the problem more that we have an overly complex overlap of different regimes, rules, and regulation, or is it more critical that we have different courts and tribunals who have the ultimate authority to decide on that regimes? And so if it would be in the second way, if the latter would be true, would you have any idea how to overcome and to make, you know, the adjudication more efficient given the regime collision? Thank you.
Thank you. So the second question of this last round, you see on the screen here, is the shipping industry willing or capable of regulating the environmental standards to adopt MARPOL standards? My personal view is they don't have much of a choice depending on the flag. So this might be relatively, ask for a relatively short answer. Last question, Eric, for this morning session, please.
Thank you. Thank you. I would like to ask a question to the last speaker, Ms. Romain. When we saw yesterday about the last part of your presentation about the ship source pollution directive, when we saw yesterday on the slides of Professor Ringboom, you were up right of the screen. He said about implementation, it was not contra legem, he didn't want to put it there, but the definition of before incurring penal responsibility is not the same as in MARPOL. So my question to you is, how do you see yourself? Where do you place yourself? Is this moving international law forward, or is EU neglecting international law, trying to have some other views, or is it simply trying to implement international law? Thank you.
Would you like to respond directly?
Yes, thank you for the for the question. And indeed, the 2005-35 goes beyond MARPOL in these, particularly criminalizing also the crew on board, and then this was also part of the Intertanko case at the time. These are issues that we will need to look at in the impact assessment. And one of the big objections of the member states during negotiations when the Commission and the Parliament tried to get the extension of the scope of this directive to also include the other MARPOL annexes was particularly this point. They said we cannot now, through the PRF directive, extend the scope without properly looking into these issues, in particular where the directive is going beyond MARPOL, whether this is indeed suitable also for other polluting substances, and what can be the impacts of this. So this will be one of the legal questions that we will have to look into. I don't have a ready answer yet, and where this will then be going in the future. Will we be retracting? Because one of the possibilities of a revision of this directive is that we bring it fully in line with the MARPOL Convention, as we also did with PRF. PRF was also going beyond MARPOL, and we saw that in practice this was resulting in a lot of legal inconsistencies, undermining the actual purpose of the directive. So we said we have to take a step back. When we define the delivery obligation, it will have to be fully in alignment with the MARPOL discharge norms, which in the meantime have also become stricter. So we had also to take into account developments there. So again, I think this is a very valid question that we will have to be looking into during our impact assessment process.
Who wants to tackle the fragmentation question?
You know, it's interesting. I didn't actually use the word fragmentation. My preference is actually to think more in terms of international having developed in silos. I don't use the term fragmentation for a very good reason. It's because our understanding of problems has evolved. But we had the institutions already in place. So certainly with climate change is a very good example how essentially the environmental problem has crept also into an emissions issue, an additional issue for greenhouse gas emissions for ships. So it's a problem that has evolved, and therefore we have different regimes that now apply, to the same problem. So to me, the real question is, how can we in international law promote better inter-regime efficiencies? And that's an interesting challenge. Now, the Law of the Sea Convention has a number of provisions that are relevant here. Article 237, 211, which speak to the convention's relationship with other instruments. And then we have a range of rules of reference in the convention concerning the role of the IMO with respect to generally accepted practices, international rules and standards. So my starting point to your question would be, certainly with the Law of the Sea Convention, there are at least a number of provisions there that help define the relationship with other instruments. And then, of course, what is not addressed by the Law of the Sea Convention? Remember what's in the preamble? Continues to be addressed by general international law. So, so if you think of it that way, I think that would be a good way, coupled also with the Vienna Convention on the Law of Treaties and the relationship between instruments, how we might address this issue of potentially inconsistent responses to the same problem. And it could well arise in the context of a trade dispute that might have a climate law dimension to it, potentially a measure as part of a nationally determined contribution that might be seen as violating most favored nation status. And then the issue is, how do you characterize that? And you are absolutely right. It really depends what tribunal it goes to. If such an issue, for instance, arose in a Law of the Sea context, it will be very interesting to see what the tribunal would do. The tribunal has been very creative, in my view, in looking at Article 192 as being nourished by other instruments of international environmental law, and there is nothing to suggest that those could not include climate law. I would argue that the Paris Agreement potentially could be brought under the umbrella of Article 192. Of course, we can continue to discuss that. But if you have something which is characterized more narrowly as specifically a discrimination issue, and it goes before a WTO panel, I think you're going to see just WTO rules apply. And that is where we could have a potential inconsistency.
Maybe a word from my side on the question from the webinar, because I've just said a bit laughingly, well, do they have a choice? But truly, if we take the example of the sulfur reduction in fuel, of course the shipping industry is willing and capable. They're preparing now. It was important for the shipping industry to have the alternative of scrubbers. I have my own opinion on the usefulness for environmental protection on scrubbers. But yes, the shipping industry is reacting to MARPOL standards. They have to be, because they do have, at least if the flag states are members, to the relevant annex. Plus, they can face hardship when they come to ports. So again, the issue here is again about having a level playing field, and the idea is to have the same economic hardship for the sake of the environment on all on potentially all ships, and the shipping industry is well prepared to comply with it. In the end, although it goes back to enforcement, and I find it very striking that, Alikas, your examples of penalties, of fines that are very moderate. So indeed, there could be then an issue that the shipping industry, not the industry as such, but specific single ships, try to evade certain standards, and then we do not have, maybe not have adequate responses. All right, so we finished just in time because we started a bit later. We have further questions now on the screen and in the audience. I'm aware, I apologize to all those whose questions haven't been answered yet. I invite you to, after lunch maybe, get back to our speakers down in the foyer to ask your questions. And thank you very much, all three of you and the audience, for your presentations, for your questions, for the answers, and see you back at 2 o'clock here for the afternoon session. Thank you very much.
Thank you. You're an excellent moderator. You really
with 3 excellent presentations.
Congratulations, folks.
All right, welcome back. I very much hope that you enjoyed the lunch break and that you used the break wisely to do some networking and to talk to all this wonderful, very diverse group of people that attend this conference. Before I will introduce the first speaker of the third panel, let me make one remark on an organizational issue. You will find in your conference materials an evaluation sheet, which I would, on behalf of the entire organization committee, kindly ask you to fill out in order to make it possible for us to learn from your criticism and what you think we could do better for the 5th edition of this conference. 5th edition, this is already quite a nice tradition, isn't it? And I think it puts us under some kind of moral obligation to continue that tradition. I'm already earning very serious looks from my co-organizers, but since I said it, you can expect a 5th edition to be there. Now, the third panel, after we have addressed the issue of responsibility concerning ports yesterday, and from the perspective of shipping in this fantastic morning session, we will now address resource responsibility. Now, we decided to address this concept from 2 or 2.5, 3 different angles, one being non-living resources, and for reasons of topicality, we decided to have a talk on international energy law with regard to the particularly controversial Nord Stream 2 project. We will then have a presentation on an issue which is right now negotiated by the Intergovernmental Conference concerning BBNJ, namely the issue of marine genetic resources from the perspective of a representative of an, how should we call the IUCN, an international NGO maybe, or maybe it is more. I had a discussion with Alejandro about the status of the IUCN yesterday. Maybe he can say 1 or 2 words about it when he starts giving his presentation. And then our third speaker is going to address resource responsibility, again, from a EU law perspective with regard to fisheries. I think this seems is going to be very interesting, all 3 subjects, and I'm very much looking forward to the 3 talks. Let me now introduce to you the first speaker, Professor Kim Talos. Kim is a Finnish national. He made his PhD in 2010 at the University of Helsinki, and we had a nice joke just a couple of minutes ago about dozens of different affiliations that seems to be common with our Finnish colleagues. We had Henrik yesterday mentioning that he even dropped 1 or 2 or maybe even 3 affiliations on the first slide of his presentation, and the same is probably true for Kim. Since 2012, he serves as Professor of European Economic and Energy Law at UEF Law School in Finland. Secondly, since 2013, he is the co-director of the Center for Climate, Energy and Environmental Law, as well in Finland. Thirdly, since 2014, he is a professor of energy law at the University of Helsinki. And most importantly, he is, since 2018, the James McCulloch Chair in Energy Law at famous Tulane Law School in the United States. Wow, how is it possible to deal with so many different affiliations? What is, I think, what becomes obvious from what I'm saying is he is one of the true experts in international energy law, and so he is one of the most competent persons to speak about the issue of resource responsibility concerning energy and the Nord Stream pipeline in particular. Kim, it's so great to have you here in Hamburg. Welcome, and we are so much looking forward to your talk.
Thank you, and thank you for having me. It's not been an easy trip. First night, I slept 17 hours when I got here. yesterday or this morning I started to sleep at 6 a.m. So it's been interesting. But I was asked to talk about a topic that combines two different things: international energy law and then Nord Stream 2 as an example. Now, I have to disclose, I've been providing legal advice to Nord Stream 2 pipeline on a number of issues that I'll be talking about, but all my opinions have subsequently been confirmed by the legal service of the council. So far, everything has been in agreement with them, or right, let's say. But I'll talk a little bit first about international energy law, what it is, and then move to Nord Stream 2. And then in the end, I'll say something more academic, I guess. But we'll start with something academic as well. So, what is international energy law? Now, the previous generation, I'm talking about the old professors, or old judges in terms of Rosalind Higgins, how they see energy law is that it's not a holistic body of law or body of rules, but rather energy law for each and every energy source is different. So energy law for nuclear has certain sensitivities, certain problems that law is trying to address. Oil and gas, same thing. There are certain sensitivities that need to be regulated. Renewable energy, same thing. So therefore, the idea has been that energy law depends on the energy source. This was at least in the energy law circles, I think also international environmental law circles, quite famous quote from Rosalie Higgins's book. But also in terms of energy law, the similar, let's say, approach was taken by Adrian Bradbrook from Adelaide, who wrote his very well-known introduction to what is international energy law. Now, I don't disagree with that, but I kind of do. We have now, as, let's say, youngish energy law academics, created a group that has started to look at what is energy law in an academic way. What is special about energy law? How does it distinguish itself from environmental law? Is it really so that it's separate for each and every topic or each and every energy source? And the work has just started. We published our first paper in 2017. Then we have a bigger group of people publishing in 2018. And the quotation is there, the Treatise for Energy Law. And it's an open access publication, so you can download it if you're interested. And our take is slightly different. We agree that there are differences, but at a fundamental level, there are also common principles or common objectives. Sovereignty is typically associated with energy. That's regardless of what we are talking about. That's, of course, very present when you look at oil and gas producing countries that make their money out of oil and gas. But it's also present in the European Union, with the national energy rights being carved out in Article 194 of the Treaty on the Function of the European Union. So similarly, energy security, that's always a consideration, regardless if we're talking about nuclear or renewables or whatever. So to us, yes, there are differences, but there are these common underlying principles that could then guide decision-making and other things like that, but we'll develop that in the future. A conceptually different approach is provided by a distinction that I often hear Norwegians do or making, which is a distinction between resources law and policy and energy law and policy. And in this distinction, resources law refers to upstream sector. And the idea is that extraction of oil and gas has certain objectives: exercising sovereignty, revenue maximization, demand security. All these are very important. But if you take out oil and gas and put diamonds instead, or gold, it's not that different. So it's not energy specific in that sense. Of course, there are certain things, but it's a resource specific issue. Here, energy law and policy refers to downstream markets, where that energy product is then turned to electricity or consumed as it is, and then in the end consumed. Here, the considerations are very different. We are talking about security of supply instead of security of demand. We are talking about as low cost as possible and not as high cost as possible. And modern energy economics, or I guess any economics, would suggest that that is best reached by shorter term trading and markets that will then guide us to the best possible result. Now, on the resources side, the demand security is typically sought through long-term contracts that bring that stability that we want, or they want. Now, this upstream, downstream, or resources law and policy and energy law and policy, it creates tensions because of those conflicting objectives of low cost, high cost, security of demand, security of supply. Sovereignty is always a problem and creates a lot of problems. And this conflict is very apparent if we look at natural gas world. And here I thought that Nord Stream 2 is a good example of that. It's not a pure upstream, downstream question. By the way, do you understand what I'm talking about, upstream, downstream? Gas production, gas consumption. Because we're talking about Russia, and there are other political elements there than purely upstream, downstream. But this same conflict between a producing country and a consuming country is apparent everywhere in the world. You see that happening everywhere. United States, even if it's producer, it has a huge difficulty in relying on anybody for energy product, especially Middle East. And so this conflict is quite apparent everywhere. And it partially explains the very strange behavior of European institutions, European Commission in particular, in dealing with this project. And that's what I'm going to really talk about for the next 10-15 minutes. So just so that everybody understands what we are talking about, Nord Stream is about 1,200 kilometers offshore pipeline connecting Russia and Germany. It's about 10 billion or 9 billion euro cost. It should be operational by the end of this year, but Danish environmental agency, I don't know what it's called, a couple of days ago suggested that there is a need to consider a third route and create an environmental impact assessment for that, which could mean, of course, that it's going to be delayed. You know better how long these things take than I do, but I assume this end of this year is no longer an option. Nord Stream 2 is 100% owned by Gazprom from Russia, which is the source of all these issues. And it has financing agreements with European partners. These partners were supposed to be shareholders, but the Polish antitrust authorities concluded that it would violate EU competition laws. The Nord Stream 1 or Nord Stream pipeline has this type of ownership structure instead of having financing partners. But that's not where the difficulties of Nord Stream 2 ended. So this is a map of how it goes. You'll see it goes from Russia through Finnish exclusive economic zone, Swedish exclusive economic zone. The intention was that it runs through territorial waters of Denmark and then into German waters. Down the line, that pipeline can then supply most of Europe because the gas pipeline network today, unlike 5 or 10 years ago, is highly interlinked and gas can move quite freely in all kinds of directions. So what has happened with what I've called in some of the articles the Nord Stream 2 saga? There have been 3 different ways in which European Commission and certain member states have tried to either prevent or complicate the project. I'm not going to talk about United States, which has threatened German companies, other companies with sanctions if they cooperate with the project, but I'll focus on European aspects only. In the first step, there was a claim that the gas market directives that we have today apply fully to this pipeline, both in the territorial waters and in the exclusive economic zones. That would have entailed that the ownership structure would have been changed. The idea, in my understanding, and this is just my understanding, was to try to force Russia to open up Gazprom's export monopoly. But that's my speculation. It also would mean that there would be some kind of third-party access regime, regulated tariffs, transparency, and so on and so forth throughout the pipeline. I'll show you in a second that proved to be wrong, and it was very clearly wrong. The next step was then that the European Commission said that there are certain problems, and we need to negotiate an intergovernmental agreement between EU and Russia that would be based on the principles of EU energy law. That proposal is still pending as far as I understand, but it didn't go that well in the end. Even if it's pending, it's currently dead. It might spring up again with the latest twist, which is to modify the directives so that they would apply to this pipeline, either fully or in part. All this was done ad hoc while the project was already running and the final investment decision has been made. So we changed the laws and we tried to do all kinds of funny things to prevent a project. Why is, of course, a question. I've spoken with a lot of, let's say, member state representatives from various member states, and there seems to be two reasons. First reason is the logical one, or to me at least, it's Russia, and it's Gazprom. So of course you have certain countries that, for political reasons, good or bad, don't like to be dependent or to have anything to do really with Russian gas. But then what was interesting, the other reason that I keep hearing is to show Germany that they are not running the show in EU. To me, that was a surprise when I heard it the first time, but it's been repeated now a couple of times. So I don't know what it is, but maybe something with both of these things. But first to the claim that EU law is applicable, and I need to speed up, to this pipeline. EU law clearly is applicable, right? You need to do an environmental impact assessment. It's based on EU law, so EU law is applicable. But whether EU gas market directive is applicable is a different thing. And here you can approach this question when you analyze whether it's applicable or not from three different levels. You can look at the Law of the Sea Convention, which you know better than I do. Law of the Sea Convention doesn't allow the coastal states full sovereignty in exclusive economic zones. So operational details of the pipelines cannot be regulated in the Finnish and Swedish exclusive economic zones. And in Denmark, we moved to territorial waters, but Danish law itself says that if there's a pipeline passing through the territorial waters which is not connected with its network, we don't apply the law. You can then look at European Union laws, the directives. It is clear that the directives were not meant to apply to these offshore pipelines that bring gas to EU. There's legislative history, practice. This has never been done to any single pipeline. So this is completely different treatment. And then you can look at the national laws. You looked at laws of Finland, Sweden, and Denmark, and none of these say that the law is applicable. So very clearly it's not. So the next step was then to have this IGA, Intergovernmental Agreement. The Commission claimed that it is a necessity, it's a legal necessity, because there is a legal void, or there is a conflict of laws, either or. Conflict of laws in the sense that Russian law and European Union law conflicts because they are they're completely different. But in reality, there's of course 1,000 kilometers between those two laws, so there is no conflict. The other thing is that there would be a legal void. There is no legal void because national laws apply, EU law applies, and international law applies. It just doesn't mean that the operational details can be regulated. And then so the Council Legal Service essentially said then that we don't need this. It's a political option if we want to have. These agreements are quite often concluded always to support a project, not to prevent the project. So this is quite common practice, but it's not necessary and it's not done always. And then there's a question of decision making, but let's not go into that. So it is not necessary for any number of reasons. One of the reasons for an IGA seemed to also be the necessity to ensure that transit of gas through Ukraine continues once we have 2 Nord Stream pipelines under the ocean. Now, to me, I'm not sure whether an IGA that should support a pipeline project is the right place to agree on transit through Ukraine. Those are a bit separate issues, so it's the wrong instrument to do that. Here, the question about competence was basically, Commission is saying, or was saying, that it is an exclusive EU competence, therefore there is no need for unanimity, and the idea was that this IGA could affect or alter the scopes of common rules. But because the IGA would have been for the exclusive economic zone, or let's say it would be for the offshore part of the pipeline, and EU law applies for the onshore, there was no alteration because they were not overlapping systems, they were next to each other. And there's other stuff as well. I mean, it wasn't EU energy law, it was principles of EU energy law, and so on and so forth. Now, because none of this worked, that request is still pending to have an IGA, or have the right to negotiate an IGA. But the Commission came up with a proposal to change the law because it was necessary for the completion of the markets and for security of supply. Well, that argument was never made in any other document before this. We had ongoing changes going on, but it was never mentioned. So suddenly, there is an urgent problem. And in reality, markets are working better than ever. Security of supply is guaranteed through high degree of diversification. We can import 40% of our gas needs through LNG today. Those LNG terminals are not just used. They are running at 20% capacity or 25% capacity. So the arguments are not really there. So this is very clearly, it has nothing to do with markets or security. It's a Lex Gazprom 2 instrument, but it has significant damage or collateral damage to other pipeline projects, the ongoing or completed projects, because their legislative framework will now change. So all these pipelines that I mentioned here will, in theory at least, have a new framework, which requires negotiations with the upstream partners, which are complicated because of this conflict between upstream countries and downstream countries. The existing system was good because the upstream country did what it did in the upstream. There was a pipeline that was not under regulation of neither of the two, and then all the gas volumes that came to Europe were regulated at the landing terminal. So the effect, unless you want to open the upstream country, the effect is, let's say, negligible. This is what they did. And this was confirmed 2 days ago by European Parliament vote. Now it goes to Council voting. But there's no reason to suspect that they wouldn't approve it, of course. So the legislative technique to modify the directive is interesting. The Commission and then eventually now the entire legislative machinery of EU, they just changed the definition of an interconnector. Now that definition only plays a role in one single article of the directive. This is why it creates certain other complications, but it only plays a role in a regulatory exemption regime. But because of this, we now include these offshore pipelines. But what is, in my understanding and my bet, going to be the next fight is the interpretation of this provision. Because it says that a third country, it applies to up to the territory of the member states or the territorial sea of the member state. It's not states. Which means that this directive starts to apply from the border of the territorial waters of the member state where the first interconnection point with the member state's network is located. Do you understand? Where the pipeline connects to the European grid, that member state's territorial waters is where this directive starts to apply. This means Germany in case of Nord Stream 2, which means that we need to create a virtual entry point in the middle of the ocean. What is it? You know better. It's 12 nautical miles. That's where you have a virtual entry point into the gas system. And that, from that point on, you apply all the EU energy laws. So there's a need for restructuring of Nord Stream 2 project, clearly. There's also a need to provide third-party access, but nobody can access it except Gazprom, because they have export monopoly. So there will be third-party access, but it's not going to be real. So the question, of course, is what's the point? But there are some other interesting examples which I'll talk. I have about, do I have 10 minutes? One of the, well, the objective of this legislative change is clearly to catch Nord Stream 2 within the regulatory framework EU law. None of the other pipelines, at least today, will be affected. It's only going to affect one single pipeline, and that is Nord Stream 2, because all future pipelines can now apply for that regulatory exemption under Article 36, because that's under the definition of an interconnector. And it applies to interconnectors which are so risky that unless they would get an exemption, they would not be built. In terms of Nord Stream, it's too late. Final investment decision has been done, so you can't say that it would not be built. Also, Commission has misused that provision in the past with the Opal pipeline, so I don't think that would be a good idea in any case. But future pipelines can be exempted from ownership unbundling and access regimes and regulated tariffs. If you have a pipeline that has already been completed, you can have a derogation under Article 49A, which is not the same as an exemption, it's a derogation. Derogation is available for completed pipelines, and again, no ownership unbundling, no third-party access, no regulated tariffs. It's simply the only pipeline that doesn't fit in either of the two categories is Nord Stream 2. To me, from an EU law perspective, I can't understand this. It is clearly discriminatory. The intent is being discriminatory to one. You try to single out one pipeline. When you looked at some of the previous versions, there was also a version that would say that only pipelines with more than certain capacity would be caught. There are only one of those pipelines, which is Nord Stream 2. Well, Nord Stream 1 as well, but so it was almost comical how they tried to single out the pipeline. But another question that it raises is in relation to these member state energy rights. So member states should have the right to make the decisions on their structure of supply and choices between energy sources. Now, if you now, with these new rules, move the decision-making on future and existing pipelines to European level, does that not impact the national energy rights, which are guaranteed by the treaty? I don't have an answer to that. It appears to me that it would. But these are complicated things, as we know from renewable energy targets. It's not obvious what constitutes affecting these. But it is an interesting question. Now, I just put in a slide on international energy law and Nord Stream 2. How does international law, not international energy law? I count this to be part of international energy law. I'm sure you count this to be part of international environmental law or oceans law in the first section. But to me, this is energy law as well. Obviously, the UN Convention Law of the Sea had an impact. Actually, the reason why it applies to the territorial waters and not exclusive economic zones was the UNCLOS. Because the interpretation of Council Legal Service, contrary to what Commission claimed, and I would share my view is the same as the Council again, that UNCLOS does not give you the right to operate, to decide on the operational details of the pipeline in the exclusive economic zone. That right only kicks in when you go to the territorial waters. Therefore, they excluded the original proposal, all the way to the last versions, included the entire EEZ as well. But that was taken out now. So now it's the 12 nautical miles. So that has a big impact in this particular case. Quite fundamental, I think. WTO law and Energy Charter Treaty or International Investment Law kicks in my opinion, now. Once that directive has been passed, there is a legitimate question of WTO compliance. In the decision on Russia-EU, certain measures relating to energy sector, that the panel report came out in August last year, essentially saying that measures that might be internal, but that reduce the possibility of Russian gas to flow into Europe can be seen as discriminatory. There are certain things that in the report which I think are wrong, but I'm sure all of us, the long report, all of us can find those things. But that seems to be the basic message. It's now up to appeal. Whether it can be appealed, my understanding is the WTO system doesn't function from the end of this year. But if it can be sorted out, we'll have the result of the appeal. But at the moment, that's how it looks. Energy Charter Treaty, fair and equitable treatment standard. The treatment of this project has hardly been fair or equitable. So some of the elements of fair and equitable treatment include predictability and stability of the legal system. Here, we change the laws on the go. Once the project is already running, that just sounds strange to me. Also, the question of discrimination might pop up. And then my academic section. Now, this relates to that upstream, downstream energy resources. Would there be a scope for a global legal framework for energy? Now, for those who understand resources and energy, the first answer is probably no. It's very difficult to have Saudi Arabia and some of the other big producers agree with Finland and Sweden. Norway might agree, I don't know. But we do have examples of this type of development. The question is whether this wave of sort of nationalism that we see around the world at the moment, be it Trump or be it Venezuela or some other countries, whether that is too strong at the moment. But Paris Agreement is an example where everybody agreed on certain measures. Of course, this instrument respected the sovereignty of the states, but it's nevertheless a huge multilateral treaty that managed to get signatures. We have another project which is not as successful, but getting there, which is the International Energy Charter, which is basically, Energy Charter Treaty has launched a new, more political document, and it now moves around getting signatures and ratifications to this more politically oriented document. It doesn't have hard law as such, it has aspirations, objectives. But they are getting the signatures from countries all over the world. So I know this is a bit academic, but I think it's not completely out of question that we might have some sort of agreement on a global level about resources. I'm talking about energy resources, of course, specifically. But in order for that to work, a couple of things need to be very clear. It needs to respect sovereignty of countries. It also needs to strike a balance between climate and environmental questions and economic development. If those two things are not included, I don't think this is possible. Thank you very much.
Dear Kim, thanks so much for sharing your perspectives on the Nord Stream 2 pipeline, but also your academic vision concerning international energy law with us. I think that you perfectly demonstrated that it was the correct idea to include the subject of international energy law into the subject matter dealt with at this conference, which is, again, thinking about it in terms of fragmentation, international environmental law and the law of the sea. Thank you so much. I guess there's going to be plenty of questions, but we will reserve that for the discussion session after the two other talks, which is why I will now introduce to you our second speaker addressing the issue of resource management with regard to marine genetic resources. Our speaker is Dr. Alejandro Isa from Argentina. He holds a master from Argentina as well as an LLM from Queen Mary University, London. He also acquired a Doctor of Laws from the Universidad de Buenos Aires. He served as Professor of International Environmental Law at the University of Applied Sciences in Germany, actually, in Cologne, and is since 2005, quite some time, the head of the IUCN Environmental Law Program and the director of the Environmental Law Center of the IUCN. A real expert, and it's fantastic to have you here, Alejandro. Looking forward to your talk.
So good afternoon, ladies and gentlemen. It's a great pleasure for me to be invited to speak on this complex topic in front of such a distinguished audience. Whether I'm an expert on genetic resources or not, that stays on another paper. So let's see what I can bring you, or I can enlighten you on this particular matter that is now being discussed, or at this moment is being discussed in New York. In my presentation, I will touch upon 6 topics. First of all, I would like to give a brief introduction of the organization that I'm working with, the IUCN. Then I would like to provide some background information about areas beyond national jurisdiction and marine genetic resources, the topic that I have to speak to you. Third, an introduction on a new international legally binding instrument that is being negotiated at the moment. Fourth, the competing principles at issue in this negotiation on the international legally binding instrument. And finally, a practical approach that we would like to propose for tackling the several matters that are at issue in this international legally binding instrument. So with your permission, I would like to pass a little commercial about the IUCN, the International Union for Conservation of Nature, because some of you might know who the IUCN is, some of you might not know. I'm not going to take too much time, just to tell you that this organization, which is a membership-based international organization, uniquely composed by states, state agencies, and non-governmental organizations, was created in 1948 and has evolved over the years into what it could be considered the world's largest and most diverse environmental network in the world. This organization harnesses the experience, the resources, and the reach of its members, approximately 1,300, which includes states and non-state members, and also the input of approximately 13,000 experts in its various commissions, ranging from species survival all the way to environmental law. IUCN could be considered, and this is not something that I'm saying, but the experts say, as a global authority on the status of the natural world and the measures needed to safeguard it. For example, you will probably know the red list of endangered species, which is one of the prime products that is produced by our organization. Now, turning the page to my office, the Environmental Law Center, which belongs to the IUCN. Briefly, this organization was established in 1970 in the city of Bonn, when Bonn was still the capital of the divided Germany. Probably we were one of the first international organizations in the city of Bonn. Now Bonn is a huge hub for international organizations and primarily dealing with the environment and sustainable development. The work of the Law Center is not only on genetic resources, so we have what we can say or summarize in 4 fundamental pillars of work, being one of them the conceptual development of environmental law at the national and at the international level as a distinct discipline. So the IUCN Environmental Law Center has initiated several discussions on multilateral environmental agreements, such as the Convention on Migratory Species, the CITES Convention, more recently the Convention on Biological Diversity, and now we are engaged in the discussions on the Supplemental Agreement on BBNJ. Second pillar of work is the assistance primarily to developing countries in designing and implementing the legal frameworks for the protection of the environment at the national as well as at the international level. Strengthening capacities for environmental law. So during lunch, we were discussing with the 2 ladies that were presenting before the importance of capacity building. It looked like as if it were something very much related to the implementation of the Rio Conventions in the 90s, but now we realize that capacity building remains a fundamental topic for all of those that are dealing with environmental law at the international level, and it is a fundamental vehicle for ensuring implementation. And finally, the dissemination of legal knowledge and information. We are the custodians and the management unit of ECOLEX, which is the gateway to environmental law. It is a comprehensive global database on environmental law jointly implemented with UN Environment and FAO. And that's it about IUCN. Now, let's start, I would say, with some basic definitions, because I don't think, I tell you quite frankly, when I was invited to speak here about BBNJ and genetic resources specifically, I was really struggling the way in which I should organize my presentation. I hope that I can at least trigger some discussions in this audience, and by way of enlightening around the main issues that are being discussed at the moment in New York. But let's start first with what are areas beyond national jurisdictions? And allow me to put this picture about the maritime zones that you all know better than me. We have the territorial seas, we have the exclusive economic zone, we have the continental shelf, we have the high seas, we have the area. The area and the high seas are considered areas beyond national jurisdictions. And one of the main issues is that this division that you can see in this graph of the ocean into jurisdictions is not based on science, but on political compromises. From an ecological perspective, it does not make sense to draw a jurisdictional boundary at the 200 nautical miles or between the seabed and the water column. These areas are highly connected, and many species pass back and forth between them. For example, a species may spend part of its life cycle on the seabed and part of its life cycle in the water. And many fish populations straddle the 200 nautical miles boundary or migrate back and forth. With that in mind, let's have a look at the map showing the areas beyond national jurisdiction. This map shows that approximately 2/3 of the world oceans lie beyond national jurisdictions, almost half of the planet. Areas beyond national jurisdictions are of key importance for food security, for carbon capture, for scientific research, and so on and so on. But then, what are marine genetic resources? And I know that in the audience are experts on that, are PhDs, people, are PhDs, authors in the audience that I hope they can help me to enlighten you if I make some mistakes in my appreciation on those issues. What are marine genetic resources? The high seas and the deep seabed contain some of the most extreme environments on the planet. Species have evolved in those areas to live in conditions of extreme heat, cold, salinity, pressures, darkness. Sometimes you see species that look of a science fiction film. And these species may have unique DNA that can be medically and scientifically important and certainly commercially valuable. And that's why we are discussing marine genetic resources here. Now let's turn to the question of why there is a need for an agreement in this area. There are many legal instruments, as we discussed yesterday and today, related to global oceans governance, as you can see on this slide. UN Convention on the Law of the Sea and related instruments, FAO related agreements, IMO related agreements and standards, UNEP regional seas conventions, others like CAMELAR, Antarctic Treaty System, species-specific conventions, and so on and so forth. So then, why do we need a new instrument? Because there is a fragmented coverage that is not comprehensive. Again, the issue of fragmentation that floats around this conference. The current coverage is fragmented, focusing on specific regions, specific species, specific sectors like fishing, like shipping, etc. As we have seen in the list, there are many legal instruments related to global oceans governance, but this is too fragmented. Also, current organizations do not have a comprehensive mandate and do not always coordinate with each other, and some regions and some sectors do not have an applicable entity. Second, There are weak regional or sectoral organizations. Different regionals, different sectoral organizations have different levels of capacities. Some are less able to address these multiple problems and challenges. Third, cumulative impacts. Sectoral activities that are regulated separately have cumulative impacts on biological diversity, and coordination is therefore absolutely necessary to address these impacts that accumulate. And finally, gaps, because emerging issues are not currently covered by the instrument. For example, access and benefit sharing in relation to marine genetic resources in areas beyond national jurisdiction. This is more or less the timeline of the development of an international legally binding instrument on marine biodiversity in areas beyond national jurisdiction, starting from 2006, going with this ad hoc, open-ended, informal working group that had 9 sessions between 2006 and 2015. In 2012, very important, in Rio+20, the states committed themselves to address on an urgent basis the issue of the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, including by taking decision on the development of an international instrument. In 2015, the General Assembly in Resolution 69/292 asked to convene the session of a preparatory committee and had 4 sessions between 2016 and 2017. And in 2017, through the Resolution 72/249, asked to convene an intergovernmental conference. This intergovernmental conference, which is at the moment taking place, will have held 4 sessions between 2018 and 2020. So we are dealing with an issue that at the moment is being discussed. So there are no fundamental definitive answers on the matter, as far as I can see. Therefore, what I'm going to propose is the topics for discussions. So the negotiations on BBNJ are always structured in 4 topics, and cross-cutting issues is included into the discussions at the end of every session. These 4 topics are the ones that you can see on the slides: environmental impact assessment, capacity building and technology transfer, area-based management tools, and marine genetic resources. Why environmental impact assessment? Because this topic relates to the conduct of activities in areas beyond national jurisdictions that may cause substantial pollution or significant harm to the marine environment in areas beyond national jurisdiction. Different questions were raised, such as the kind of activities that will trigger an environmental impact assessment, or who will make the final decision, or who will carry out the assessment, or what is the effect of the final decision on the EIA. These are fundamental questions that are part of the negotiations at the moment in New York. Second, capacity building and transfer. How will capacity building be coordinated? How will capacity building be funded? Let's turn into area-based management tools. For example, MPAs, for example, no-take zones. One of the main issues is to define what are these area-based management tools, and to identify, for example, how marine protected areas will be managed and enforced, and how they will be established in the high seas. Finally, marine genetic resources, which is the topic that we are focusing on. In the discussions on marine genetic resources, how I am with the time, Alexander? Am I okay? Okay, thank you. In the discussions on marine genetic resources, there is, I would say, a practical aspect and an abstract aspect. And this is my proposal, as I said, to bring to your attention. The abstract aspect is to know how to reconcile two competing principles: the principle of the freedom in the high seas and the principle of common heritage of mankind. And the practical aspect is to know how to practically manage genetic resources and share the benefits deriving them from without blocking scientific progress. These two sections that come now will try to address these two questions. The central tension in the question of governance of marine genetic resources is between the principle of freedom of the high seas and the common heritage of humankind. Let's first look at the principle of common heritage of humankind. The United Nations Convention on the Law of the Sea, I know that you know that, but let me repeat that because I think the devil is in the detail, and this is exactly what we need to consider if we would like to discuss about this matter, provides that the area and its resources are the common heritage of mankind in Article 136. The area is defined as the seabed and the ocean floor and the subsoil beyond national jurisdiction. However, the resources are defined for this section as mineral resources. And therefore, what does this mean for genetic resources? Are they included in common heritage of mankind? I think this is a valid question, because some states argue that biological resources are not explicitly excluded, and so the area should be interpreted as to include them. Other states claim that because resources is specifically defined as to cover only mineral resources in the area, the scope of common heritage cannot be applied to other types of resources. Therefore, in a nutshell, common heritage of mankind under the Convention on the Law of the Sea means that the marine resources of the area do not belong to anyone, a state, a natural or a judicial person, but to mankind, to everyone. Therefore, the benefits from the resources governed by common heritage of mankind should be equitably shared with everyone, mankind. The International Seabed Authority is the organization, or will be the organization, in charge of controlling that this principle is respected. Now, the principle of the freedom of the high seas. Under the Convention on the Law of the Sea, the high seas are governed by the principle of freedom of the high seas. This includes, as you know, but let me repeat, the freedom of scientific research, and means that the states are free to conduct activities in the high seas, but cannot interfere with the freedom of other states to exercise this freedom. Many states argue, and this is also part of the negotiations, that genetic resources fall under the freedom of the high seas. They argue that the principle of freedom of the high seas applies explicitly to the water column. In addition, they would include living resources of the area, as they are not explicitly included in common heritage of mankind. However, it is important to note that the freedom of the high seas, as you know, is not an unconditional freedom. It is limited by the conditions laid down by the Convention on the Law of the Sea, including strong obligations to protect and preserve the marine environment and to have due regard to the rights and respect to the activities in the area. So what do we do with this mess? These two competing principles give rise to a number of questions that I would like to consider in this conference. Are genetic resources in the area governed by the principle of common heritage of mankind? If they are not, are they instead governed by the principle of freedom of the high seas? Or are genetic resources in the high seas governed by the principle of freedom of the high seas? And if not, could they be governed by the principle of common heritage of mankind? And if the Law of the Sea Convention is not clear, and this is the key question, can an implementing agreement define a new regime for these resources? To answer these questions, it is possible to say that at first, having a different regime for the area and a different regime for the high seas would be unworkable. Secondly, the regime for marine genetic resources in areas beyond national jurisdiction needs to work in tandem with a regime applying within national jurisdiction under the Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefits arising from their utilization. So, what kind of system do we want? What is needed? There is, in the negotiations at the moment, a growing consensus of what will be needed to effectively manage or to effectively have a regime for managing these genetic resources in areas beyond national jurisdiction. And these include facilitation of access to marine genetic resources and promote research that will benefit humanity. Enabling the participation of all states, including developing countries. Ensuring sharing of non-monetary benefits, including sharing research results and scientific data, and involving developing country scientists in research. Consider an option for sharing of monetary benefits and providing, at the end of the day, legal certainty. Possibly most important, there is a need for clarity about the legal status and the obligations relating to marine genetic resources. What could this all look like? There are different ways to realize this type of system in the agreement. One general proposal would include, for example, a requirement that research cruises file a pre- and a post-cruise report, including information on where research was conducted and what genetic materials were accessed and where they are deposited. Developing countries' researchers should have opportunities to participate in those cruises, possibly for a requirement that certain number of research places be made available specifically for researchers from developing countries. Metadata relate to samples such as where they were collected, when and by whom should be attached to the samples and should stay with them and be disclosed in any publication or in any patent application. Samples should be deposited in biorepositories and there should be opportunities for other scientists, including from developing countries, to access the samples and associated data for their own research. There could be a small payment at the time of patenting or licensing, which would go into a global fund to be used for purposes of marine science, conservation, capacity building, and supporting the agreement. And information from cruise notifications, opportunities for joining cruises, data relating to samples, and funds available could be shared through a clearing house mechanisms. I'm concluding. So, sovereignty versus freedom at the end of the day. After these developments, we can possibly, I would say possibly conclude, and certainly pose the question in comparing the challenges ahead of international governance of biodiversity within national jurisdiction with those challenges ahead of international governance of biodiversity in areas beyond national jurisdiction. Within national jurisdictions, international governance of biodiversity is related to the sovereignty of states, while beyond national jurisdiction, the governance of biodiversity at the international level is related to the freedom of states. In addressing biodiversity laws within national jurisdictions, we often face challenges related to state sovereignty, which does not let the global community, so to say, just to dictate protection measures. The response to these challenges, sovereignty challenges, is certainly consent. States express their consent via international agreements. In addressing biodiversity laws in areas beyond national jurisdiction, the central challenge is not related to state sovereignty, but to their freedom, the freedom of the high seas. No one has jurisdiction, no one and everybody has rights. One of the fundamental then remaining questions is to know how do we control, at the end of the day, the activities where states have no jurisdiction. The answer could be that states have responsibility over activities within their jurisdiction or control, and these activities could be activities carried out by vessels flying their flags, or activities carried out by their nationals, and there are countless examples in Article 94, in Article 139, in Article 213 and 219. But these are the main questions at the moment being discussed when this agreement is being negotiated in New York, and with these questions I would like to conclude my presentation. Thank you very much.
Thank you so much, Alejandro, for this wonderfully concise and very clear presentation. I also appreciate very much that you gave us your perspective on a potential avenue out of the dilemma of the two, of the dichotomy of the two colliding principles, which I guess is such a strong dichotomy that it may ultimately even threaten that there will be an ILBI, as it is often called, an international legally binding instrument at the end of the day. So I guess that is something we can follow up in the discussion. Thanks very much again. It's my pleasure to introduce to you the third speaker of this third panel, Dr. Till Marcus. Till received an LLM of the University of Rotterdam, a PhD at the University of Bremen, by the way, dealing with European Union fisheries law, so he is definitely one of the real experts to talk about the subject matter that he's going to address. He then served as a postdoctoral research fellow at the University of Bremen, has published widely on international European environmental law, in particular on fisheries. I think that's fair to say that this is really one of your main research focuses, and just since very recently, since March 2019, this year, he is a, how would that properly be called? Research associate, professor, no matter, at the Department of Environmental and Planning Law at the Helmholtz Center for Environmental Research in Leipzig. I should also mention that I learned that Till has just a couple of weeks ago submitted his Habilitation, which is under German academic traditions the magic moment in order to qualify for full professor. Congratulations and good luck for the last steps to be taken. But now the floor is yours for your presentation concerning resource responsibility through European regulations for trade in fisheries products.
Thank you very much, Alexander, for this kind introduction. And thank you also for inviting me. And thank you also, Nele, for inviting me and giving me the opportunity to come back to fisheries, because I haven't been working on fisheries like for the last 3 years, basically. But I was asked to come and speak, and I thought about, what can I offer? What do I have to say with regards to resource responsibility and the EU? And I immediately came back to a topic that intrigued me from early on when I started to deal with fisheries and research on fisheries. And I will start, it will be an exploratory talk, a little bit like my predecessor did, and I will ask questions and I will come up with, and I try to solve a very, or bring order to very fuzzy discourse. And it has a lot to do with the effects of international trade on resource responsibility in the area of fisheries, and maybe with the European, or particularly with the European contribution to this, and the European trade policy's possible contribution to this. Okay, those of you who are not from Hamburg, this is a picture of the sign which points to the Altona fish market, which is a very famous fish market in Europe, and particularly, of course, in Hamburg and in Germany. It used to be the trading place for fish in Germany for hundreds of years, and it's probably one of the oldest maritime fish markets in Germany, and it dates back to the 14th century, and at that time, Hamburg and Altona were still two cities. And of course, today, this is why I used the picture as a starting point for my talk, just want to use it as a means of contrast, because today, fisheries trade is very, very different from what you can see when you look at the old history of trading places. Today, fisheries trade has become a global business on virtual markets, and it generates a net worth of 143 billion in 2016. 32% of all produced and caught fish enter the export. And roughly 60 million tons are being traded every year. Trade relations have become complex, and traders are located all over the world. And trade in fish and fishery products is extensive and shapes global production and consumption patterns. Accordingly, governance or regulation of trade in fish and fish products provides an avenue or an opportunity or a means to make an important contribution towards resource responsibility. So in my presentation, I will try to inquire how the EU's trade policies and laws concerning fisheries products fit into this picture, whether or to what extent they can be regarded as resource responsible, and what can possibly be its contribution to resource responsibility. Perfect. So very briefly, I will give an overview. First of all, I would try to introduce a reference point for what can be regarded, or a reference point for resource responsibility in the area of fisheries. I will then try to define what trade in fisheries products actually includes, because that is a little bit tricky because of some law of the sea issues, and how the topic can be related to resource responsibility. I will also look at the EU fisheries trade regime and try to assess which aspect of it can be regarded as resource responsible, and where there possibly might be certain pathways or avenues to improve the system. All right. Well, it's fair to say, and I would just like to briefly remind us of what resource responsibility in fishery means. And it's very well captured and represented by the 14th SDG, and we've seen it today already in the talk of Alike. And what it says basically is that fisheries is one
aspect of managing uses and conservation of the oceans and the seas. Fisheries policies used to be very much concentrated on stocks and the effects fishing activities have on stocks. But over the years, over the last couple of decades, environmental aspects and requirements were increasingly being taken into considerations. And the ecosystem approach emerged, the precautionary principle emerged. So in a sense, that is very clear. Fishing is part or is taking place in a marine environment that has to be used and conserved. So Target 14 provides a more specific reference level, and that is, of course, the maximum sustainable yield. And it's not only SDG 14, but it's a lot of international legal instruments which also refer to the maximum sustainable yield as a reference point for fisheries management. It's national laws, it's UNCLOS, it's the FSA agreement from 1995, it's the Code of Conduct, it's European law, it's New Zealand law, you name it, Japanese law. You will find the MSY level in fisheries science and, of course, in the law. But to sum it up, it's MSY levels, maximum sustainable yield levels, as, you know, and accompanied by natural or environmental requirements which need to be considered. So where are we now? Every 2 years, the FAO publishes its huge report on the status of world or global fisheries stocks, and it just also switched its nomenclature to so-called fully fished criteria into the MSY criteria, and it says that almost 60% of all commercially exploited stocks are fully fished at MSY levels. So you could say that it's sustainable, but it's a very rough assessment in a sense, and it does not necessarily take into consideration ecosystem requirements. 7% are fished below MSY levels. That means, or that leaves 33% are being fished beyond maximum sustainable yield levels. And that can mean a lot. That can mean that they are already outside safe biological limits, which makes them collapse more or less, or could lead to their collapse, or it could be just a little bit above the MSY level. It's a very rough assessment, as I say. But so here we are seeing these numbers, and the FAO clearly states that fishing pressure is increasing. It has stabilized through the 90s, early 90s, at some huge number, but in a sense, it is very easy to see that these numbers will, or that the fishing pressure will increase. We will have more people, we have rising living standards in many parts of the world, and we have an increasing technology, or better technology, for hunting down the last fish stocks, or not the last fish stocks, but the fish stocks. And some fisheries scientists say that these numbers of the FAO are overly optimistic. So there is a sense of urgency here. Okay, trade in fisheries products. When we want to find out what trade has to do with fishing pressure or the use of fisheries resources, we really need to take a brief moment and look what falls within this topic. And in general, you could say that's imports and exports. Either fisheries products are consumed or processed within one country in which they have produced or where they have been caught, or they enter the export and are sold to other countries. Because of, this would also include, and that's like the law of the sea aspect to it, if a vessel carrying a third country flag is landing directly their catch in European ports, this would be part of the trading regime. It also includes imports from EU companies' subsidiaries which are located in third countries, and it would also, if I'm not mistaken,
all imports from overseas territories. We have an expert on fisheries here from the European Commission. He might correct me if I'm wrong, but I think this includes imports from overseas territories. So what does not fall within the remit of the trade policy? But that's, of course, I mean, for all of you, you're law of the sea lawyers, or you're familiar with the law of the sea, but if you would give this talk to environmental lawyers, you would really have to explain it to them. Of course, it does not include those ships which have or carry the flag of a member state and which go out and fish in the territorial waters, the EEZs, on the high seas, or in the EEZs of third countries where this fishing is based on access agreement. A lot of people include subsidization into the topic of fisheries trade. Subsidies have a strong effect on trade, obviously. But, for example, from a European law perspective, subsidies have many other functions and purposes. They have environmental purposes, they have labor market purposes, they have structural purposes, and they are more seen as part of the structural policies and not necessarily directly included into the topic of, into the frame of the trade policies. But in many contexts, like the WTO, trade agreements include the topic of subsidies, but we will treat subsidies a little bit less here. So, just very briefly, now, as I said, 30% or 35% of global fish production enter international trade. And this graph roughly shows you the amount which is being exported by developing countries and the amount which is being exported by developed countries. What this graph doesn't show you is where the fish is being imported, basically, and who is gaining a lot of fisheries products from international trade. And it's really interesting to see that the European Union is getting 26% of all the fisheries products which are being traded globally. Was importing 26% of all global imports, or traded goods. And 60% of the fish consumed in the EU is from outside the EU. It's caught or produced outside the EU. In Germany, actually, is, I think, much more than 80%. So, in fact, the trade regime of the EU covers a huge proportion of the world's traded fish. The trade deficit is also visible in countries like Japan and the US, but as I said, the EU is a special case because it really gets a huge proportion of the world or globally traded fisheries goods. Now, are high import rates really an issue for resource responsibility? Sorry. Well, there is a rising demand in fisheries products. And on the other side, we see heavily exploited stocks. And there's a tension in it. It at least evokes the question whether there is a problem. And this discussion is being ongoing for a long time, and I've always wanted to come back to it because it always seemed blurry to me, and the arguments are very much emotionally, or you could say even ideologically, being discussed. Well, in general, you could say that there's some basic, or one group of people really sees it critical, and the other group is, believing in free trade and the benefits of free trade, and several arguments circle around these basic assumptions. And those who see it, kind of believe in the positive effects of international trade in fisheries products, like, for example, in the WTO negotiations or in the FAO, certain benefits of international trade are being emphasized. And that is, for example, that international trade in fisheries products creates foreign exchange for developing countries, large nutritional gains in export countries. It creates trickle-down effects in export countries, and it can serve as a motivation for sustainable management in export states. In addition, increasing options, or international trade increases options for consumers in import countries, and it allows access to fisheries resources for those states who have no fish resources or are geographically disadvantaged. The other group more or less points out the possible negative effects. And there are three main arguments. And the one is that international trade creates an unfair distribution globally of high valuable food resources. And there's two narratives around this, which basically you could summarize in first, the rich people get all the good food, while the poor get the remains. And the second one is the EU or other economic powers have used up their resources and are now increasingly fishing or increasing the fishing pressure via the mechanism of the world market in other areas. The second argument is that world trade creates an unfair competition between those industries in these exporting countries which are export-oriented versus the small-scale artisanal fisheries, and that small-scale fishers in exporting countries very often do not gain the benefits of global trade. So what do we actually know? If these discourses are very blurry, and the people who kind of agree with each other, they keep on talking to each other, and they seem to justify their thoughts in many ways, and it's kind of self-referential. So what I found, and this is a preliminary analysis, I would say that this is research in progress, and things need to be very much empirically and systematically be inquired. From the few studies that I have seen, both types of effects are visible. But as I say, many studies or arguments or articles are more anecdotal. Both types of effects are visible in some cases. So what seems to be true is that the globalization of markets, and this is very tentative here, seems to contribute to increasing fishing pressure at last. Markets rather seem to have a catalytic effect, both for positive and negative effects, and that the effects of trade depend to a large extent on the national management system of the exporting country. So this is preliminary, a preliminary assessment from what I can find. Now, how does the EU fit into that? The EU, since its inception in the 70s, and basically since the creation of the EEZ and the loss of fishing grounds for European vessels, has a significant undersupply of fish, raw material, and fisheries products. And for political reasons, food supply and promoting the processing industry were really strong objectives of the Commission and the member states in the Council. And so the EU has in general lowered or even abolished many times its tariffs for fisheries products. I forgot to say that in principle, of course, the EU is a custom union and fisheries imports subject to the common custom tariffs. So a lot of times the EU has lowered or abolished tariffs through different types of regulations. Either they're triannual autonomous tariff quotas or multilateral agreements. Particularly with the Cotonou states or later economic partnership agreements, states, the overseas territories, the parties to the European Economic Area, the 50 least developed countries, and several other African Caribbean states. In total, approximately 2/3 of all imports of fisheries products are subjected to substantially lowered or no custom tariff. On the other side, the EU has the opportunity under the market regulation to adopt anti-dumping measures. It has rarely done so, very few times as far as I can see, to protect the processing industry basically. It also, and that's not a tariff measure, it's a the EU has phytosanitary standards for fisheries products, and in principle all imports subject to the same phytosanitary measures as EU products. Some developing countries have argued that these requirements bar market access for their products. And third, and increasingly, the EU adopts regulations which restrict market access for illegal, unregulated, and unreported catches. It has started with some tuna imports, bans for tuna imports from specific countries, and now it has, since 2009, the IOU regulation, which basically established a complex system of trying to really restrict market access for those illegally caught products. Oh, sorry. So, taking all this into account, what can the EU do? And as I see it, it's very difficult to say that a liberal import regime really creates negative effects in developing countries or in other countries. What is the role of the EU? A lot of imports to the EU of fisheries products are actually not from developing countries. A large portion comes from Iceland and from Norway and other transitional or developed countries. So Iceland and Norway, of course, cannot be suspected of really managing their stocks badly. They manage them probably more successful than the EU. And so first thing probably to do was to really clarify where EU-initiated trade or imports really create negative effects. And there would probably be in some developing countries. But we need well-designed empirical research on that, and as far as I can see, there's very little out there in this regard. So, but if the EU wants to ensure that their trade policy, their liberal trade policy, does not harm resources, they would have to clarify the effects of their trade policies and their import practices. Fisheries trade is, for a long time, has been also, or the supply of, do I have a little bit? Oh, 5 minutes, perfect. Fisheries imports or supply has been guaranteed by other means. The EU has funded joint ventures, that is, joint ventures of fisheries companies in Europe with fisheries companies in third countries in order to gain access to the certificates, fishing certificates of other countries. It also has funded access agreement, obviously, and there are also, to some extent, private fishing activities outside these access agreements. So it would be really interesting to see to what extent and in what the volume really is of EU activities of EU companies in third countries, and to make an assessment of the effects of these investment policies and fishing activities and trade-related activities of these actors. So the second big step is, and that's probably the only thing really possible, or the strategy that is really possible given this very complex system and the mixed effects of trade policy and international globalization of international trade in fisheries products, is to keep on and intensify the restriction and to make it effective of or restrict imports to sustainable and legal products. Currently, the emphasis is on restricting trade to legal products. But legal products are not necessarily caught sustainably. So this can only be the first step. Make the import regime effective in the sense that it just does not allow in illegally caught fish. And second, to help third countries or important importing states in developing their management system. Because that was one of the things that seemed pretty clear, that if the management system in the exporting country is functioning and viable, export can't harm the local resources. And that would include, actually, to help third countries to achieve the public and increasingly private standards for sustainable fisheries. A lot of developing countries argue now that all these private standardization and certifying and labeling requirements makes market access for them increasingly difficult. So support also small-scale fisheries in getting access to the markets and to let them participate in the benefits of trade. And to also help third countries to prevent IUU fishing, particularly in developing countries, because that's the big challenge, to avoid IUU fishing. Okay, I just need this to say because every other thing, or to not say, would make an unbalanced picture. It's a very airy objective, but it's important to say that, of course, the EU could reduce global fishing pressures by really trying to improve their own fisheries management. And for a long time, it hasn't been very successful. There's clear signs of change, but yeah, there's room for improvement. So it could, by improving its own management system, reduce the demand pull on the global market. Okay, and finally, I spoke with my colleague in the break. Normally, access agreements include exclusivity clauses that mean that private actors can't get access outside these agreements to third countries' resources. But if there are no exclusivity clauses in these access agreements, it would be very important to get all the external activities of EU actors inside the regulatory framework of these access agreements in order to get a governance grip on it and control and have transparency regarding their actions. Okay, that's from my side. Okay.
Thanks so much, Phil. Yeah. Great job. And also for linking the issue of trade with fisheries products so well to our overarching subject, namely responsibility.
Yes.
Thanks so much.
Yes.
You stay here,
yeah.
please. And I would like to invite our Kim and Alejandro to join us here. It's time for discussion right now. So let me see whether there is already the first. I see the first two questions, three. So I will completely remain silent and give the floor to you, please. Do we have a microphone? Yes.
Hello, my question goes to Dr. Isa. Well, I refreshed my mind about BB&J negotiations after a long time. I'm just wondering, what is IUCN's position? Not status, but exactly the position. So you nicely described that this is there are opposing opinions, like part of the common heritage of mankind or freedom of the high seas, or could be even a hybrid regime, a new type of regime covering BB&J. So I saw on the IUCN's website that there is a matrix of recommendations dates back to 2015. I don't know, maybe the answer to my question could be found there, but anyway, I will be thankful if you can elaborate on that. In particular, because IUCN is not only, let's say, a legal network, but it also covers also scientific aspects of environment. So that was my question. Thank you.
Thank you very much. Let us first, if you allow, Alejandro, collect 2 more questions. Herr Catoir, please. Sitting in front of you, yes.
Yes, well, I'm a victim of Nord Stream 1. And I could make a comment of 5 minutes, of half an hour, and 1 hour and a half on what Professor Talos said. Only I have one question. Norpipe and Nord Stream 1, did you look why it was done under Norwegian law and why Nord Stream 1 went through Danish and Finnish waters? I will just say I was behind the tracing of this Nord Stream 1, and at that time we had ESPO, we had the Helsinki Convention, and we had a lot of other conventions, and the whole thing was done politically on the level of Chancellor Schröder. And I, who was responsible for the maritime law and all this, was called in once things were done. But the Polish told us, we will do everything to stop this. And we will look for any legal point in EEZ, in continental shelf, and whatsoever to stop this. And that is why this thing goes straight up north. But there are a lot of other points, and you have seen that Schröder afterwards went into the services of Gazprom, which surprised me a bit. But did you look into Norpipe and how the legal conventions were done with Norway for Norpipe, and how the legal standards were done for Nord Stream 1?
Thank you. And Aldo Kirkup, please, in the first row, or rather, 4th row. That was a very unspecific description. Sorry for that. Yes, Aldo, please.
I should carry an AIS or something so you'll locate me more easily. Congratulations to the 3 presenters. Very interesting presentations. I do have a question for Alejandro and one for Till. Alejandro, do you get a sense as to what might be the relationship between a future ABNJ agreement and regional fishery management organizations, given that these are also treaty-based and some of them are actually well-run, like Northwest Atlantic Fisheries Organization has really dramatically improved as an organization and runs what by many standards now is probably a model RFMO. So if you have something which is working there, would you want to have a global agreement affected, and if so, how so? And a question for Till. Till, it would be very interesting here to get a sense from you as to how the EU regime provides, if at all, for certification of fisheries that are being imported. So you mentioned actually a fairly high percentage of imported fish products. So how does Brussels know, if at all, where those products come from? And we're particularly concerned here with IUU of East and West Africa in particular, among other places. And just a few days ago, for instance, Sierra Leone is screaming out for help, basically, you know, essentially primarily because of IUU fishing and effectively, of course, displacing local fisher folk. Thank you.
Thanks, Aldo. We take a 4th question before we start a new round, because Nila just indicates that this is directly related to Aldo's question. I saw you raising your hand. We have a 2nd round afterwards, okay? Nele, please.
Yes, thank you, because it just goes to the same direction. A question for Till as well. Aldo mentioned certifications, and my question is going to the same direction. So is there a responsibility for the EU also to provide for more or better science, scientific insights? I like your idea to say, well, it's not about being legal, but being sustainable. But so since the EU doesn't react to its own scientific advices for their own waters, wouldn't or shouldn't there be a responsibility to provide for more knowledge, a closer knowledge gap? This is also in the context, of course, within now the UNESCO decade on marine science for sustainability. But so this is a close connection, certification, yes, but on what basis? So where does the responsibility for science go in there?
Thank you, Nele. Questions to all speakers. Kim, you want to start, maybe?
I can.
Because
my answer is short. The route of the Nord Stream 1 pipeline and then following the Nord Stream 2 pipeline is, as you said, purely political. There was my first conference, actually. I haven't studied it in the context of Nord Stream 2, but Nord Stream 1, my first conference that I ever organized was on Nord Stream 1. And we had people from Estonia speaking, a professor from Estonia, and representatives of Nord Stream 1. And, well, let's say the discussion was interesting. And the pipeline was routed through the Finnish territorial waters. But in terms of Nord Stream 2, and then a potential, or let's say somewhat likely, pipeline with Norway, directly to Poland, oh, is it to Germany? Yes, I can understand that.
That's a fiscal responsibility was with Norway, and the whole contractual basis for all civil law and international law. It was so. It's rather strange that you have an international pipeline where you do not split in the middle, but it says it's a pipeline where Norwegian law is applicable up to the point where it comes into German waters. So it's a pipeline, just to explain to everybody, and because it's a pipeline which has a very huge importance on energy law and so on. It's a pipeline between Norway and coming then nearby here to Hamburg into German waters, or Hamburg or Bremen. I don't have the geographic in mind. Only the point for energy law and for European law, who is very important, Germany was the only country who in energy issues did the reversibility. So if Russia cuts us from gas supplies, we can from one moment to the other reverse to more supplies from Norway, so that we are not in a winter where we have no heating. And the other countries didn't. And if you look into the electricity field, you have just the same thing. If you go to France, the whole French system is based on nuclear. So you can only put the energy in one direction, not in the other. And Germany is the only country where from the beginning, this issue, which is technologically and for the supply most important, has been put into account and action has been taken. All the other countries never followed.
You should tell this to Donald Trump.
Yes. And Donald Trump.
No, please. We need. I'm sorry. We need to. All speakers need to have the time to answer to the questions. Alejandro, please.
So I knew that the question was going to come, especially your question, because we are always asked, what is the position of the organization? And it's not that I'm trying to avoid, so to say, the problem, but you've got to understand what IUCN's role in the negotiations is. So we are an observer. So we are not a state. and we have state members in our membership. So, and you know the polarization, if you are following the negotiation, about the various themes that are being dealt with there. States that are opposed to dealing with issues relating to intellectual property rights, states that would like to bring that into the negotiations, states that would like to bring into the negotiations issues relating to biological, so biosequencing, or I don't know how it is called, all that stuff, and states that are opposed to that, states that are against discussing access and so on. So the organization takes a stand primarily to provide scientific and technical advice to the delegations present there and try to influence the negotiations with specific, let's say, papers, convening workshops to discuss some issues, bringing the scientific community from the various commissions of IUCN to participate in the delegation and influence scientifically from that point of view the discussions during the negotiations. So and I pulled the paper because I thought it was going to be relevant for this discussion. Our mandate to work on ABNJ comes from our General Assembly. So who at the end of the day decides what IUCN does on these matters are the members. And the members coming together in the General Assembly. So, and in Hawaii in 2016, the membership as a whole of IUCN adopted a resolution called Advancing Conservation and Sustainable Use of Biological Diversity in Areas Beyond National Jurisdiction, which specifically calls upon, among other things, the assessment of human impacts and activities, including cumulative impacts, in areas beyond national jurisdiction, the rapid identification, designation, and effective management of an ecological, representative, and well-collected system of MPAs, effective monitoring, compliance, and enforcement, capacity building and transfer of marine technology, and fair and equitable sharing of benefits. So that these should be main issues that the legal regime should consider. And this is what informs the IUCN delegations and our participation in these negotiations. So if there are further questions, we can continue coffee or after that. And concerning the other question from the gentleman relating to the fisheries agreements and a global agreement, well, again, I think this is the issue of fragmentation or full or partial coverage, you know. So if we only deal with these issues, you know, of such a magnitude and such a global coverage within a specific fisheries agreement and regime, I think that we will, at the end of the day, dealing with one little part of the whole equation. There might be other reasons, other compelling reasons in your view, because I guess that you are an expert in that particular matter that I would like to hear, but my immediate take on that will be to say, okay, because of the nature and the globality of this particular issue of A, B, and J, it requires a discussion at the level of a global agreement and not a specific one, dealing with one particular North Atlantic, South Atlantic, Mediterranean, or whatever. That will contribute to further fragmentation, in my view.
Thank you. Till, please.
Maybe just to add on to that, it's just a personal opinion on this, but what we see is, and that is the right direction of your question, we have sectoral regimes in the ocean, covering the oceans, and now we have a new regime coming in. And one objective of this new regime is to allow, for example, to establish large marine protected areas, which might affect, to some extent, or have the possibility to affect these other regimes, like RFMO regimes, which possibly can take, to some extent, into account in their management system these new objectives, which are coming into this international system. And yeah, deep seabed mining. Every regime now needs to adapt and and to orient what is going on in the ABNG regime, you know, that is coming up. So, but that is always the case when new regimes emerge, and you have coordination requirements. And we discussed it today that in the end, often it's courts who will then take a decision and say how these different regimes relate to each other, and yeah, but it's a matter of coordination that in the end will show how it works probably. But yeah, the fisheries regimes are very clear and strong and very tough in the sense with regards to their scope and competences. Okay, but that's just a thought. I had two questions that I also would love to answer now. Well, how is the EU controlling actually that fish is caught legally somewhere else, somewhere along the world? But the basic approach is that they want a complete or a very thorough documentation of where the catch or the fish is being caught, where it might have been transshipped, where it has been transported, and where it has been landed or imported, or what it was the point of entry in the EU. Also, when it comes to intra-EU trade, it still has to be very finely documented. And there's no extra certification scheme or something as far as I can see, but maybe my colleague from the Commission can say, add on to that, but and explain it a little bit better. But in other areas, we have certain third certification schemes, like in the forest trade or something like where private certifiers actually check whether the production process has been sustainable or something like that. In the Renewable Energy Directive, we have stuff, we have requirements like that. But as far as I can see in the fisheries IUU regulation, it's the basic approach is really a very tight and thorough documentation scheme. And we see that member states are struggling to control very thoroughly all the imports that are coming in. And even in Germany, we see that the government is troubled with that, and there has been disputes about it. And my colleague here, Roda Verheyen, can maybe explain a little bit more on that. She was involved in that. But yes, I'm almost done. Okay, sorry. But yeah, it's a big issue. But here we again enforcing what we really want to achieve in these agreements and regulations. Okay, the final question from you, Nele. ISIS is a real big value. That's provides a scientific base, and a lot of countries envy us for having that. But still, as you said, the political process often does not fully consider that advice. There are examples of how it is generally done in third countries. Well, they often have consultants coming in, making assessments, and then these countries negotiate, for example, with the EU. And these consultants could be, sometimes they are paid by NGOs, sometimes they are paid by the Norwegian government, sometimes they are paid by the country itself. But that would be one route to go. The GIZ funded control boards in several African countries. Yeah, and I think, and that's my final sentence, when you look at, we really you could look where the exports really seem to create problems. And it's probably a couple of countries. And then it could focus its power or its money or its efforts on these countries and try to improve the scientific basis as a means of capacity building, as a means to improve the quality of the imported products and the overall balance of that. Okay, sorry, it took a long time.
Don't worry, thank you. I didn't forget you, but we have one question which I will, is addressed to you, Alejandro, on the screen. Taking into account that you mentioned the Nagoya Protocol, how would that be applicable to the high seas or the area? What is the consequence of that? And then I would like to give the floor to the lady up there from, I think you said you're from Ghana. I'm sorry that I...
My question was actually going to be for Dr. Isa as well. You have touched on it a bit, and I guess you may not actually want to answer the question from...
No problem in answering.
You may not want to give your opinion on the matter. I was going to ask about intellectual property, actually, in the ABNJ. Would it not be better to have some kind of... if we assume that the marine resources of the ABNJ is common heritage, should we not have a mechanism which is also commonly held to hold the intellectual property of that area? Otherwise, if we leave it in private hands, it may very well exclude some of the developing states in particular. But you may not want to.
Thanks very much. Kim, a point which Alejandro, if I may, let me add maybe to...
To me?
No, don't worry.
Okay.
Not to you. Kim, I was struck that you mentioned the issue of competence of the EU, Article 194. And I do have a lot of sympathy for the idea that obviously that provision contains a clause which emphasizes the sovereignty of the member states, essentially meaning that the competence of the EU is definitely not unlimited, notwithstanding the issue whether it is a shared competence. We know this, of course, but even further, there is limitations. So my question is, what is your position concerning the relevance of this clause with regard to the Nord Stream pipeline? Is that going too far? Is there really a competence problem concerning the course of action taken by the EU? I'd be interested to learn on that.
Well, look, if I go to the to the details of the questions that you are particularly asking me, and as well as this one that is coming from somewhere in the high seas, probably, I will have to start, with the presentation once again, and probably I will ask, the Bucerius Law School to organize a conference next year specifically on this particular matter. Look, intellectual property rights issues are being discussed in different fora, and this is also a matter being addressed and discussed in New York. And some countries said just because they are being discussed in a different fora, they do not pertain to this fora. So this is another matter of disagreement in the negotiations. But I concur with you that if we go about, a regime that is primarily based on common heritage of mankind, sooner than later we will have to find a way to reconcile these two issues. There are no definitive answers at the moment in the negotiations. These are some of the contentious issues at the moment. And if I would like to respond something like that, a question that says, how would a regime like the Nagoya Protocol be applicable to the high seas? It's more or less about the same issues. As long as we do not know in which way we're going to position ABNJ and genetic resources, if it's going to be the common heritage of mankind, or if it's going to be governed by the principle of the high seas, where, first of all, we will have to decide on that, and then we will see in which way we will be able to apply or to find the bridges with the regime under the CBD. I think that's my take on that. Thank you.
Now, legally speaking, I think there is a tension. I think there is something there. But then on the practical side, it appears that the member states are largely in agreement that there is no problem because they agree on the measure. So in practice, in this particular case, it appears that it did not make a difference. But otherwise, it's a complicated provision. The limits of that provision are, to me, a little bit unpredictable, in the sense that I understand why the Renewables Energy Directive was given. It was given under the environmental competence, but there you have a similar, though not identical, provision, and that was relaxed. I think that directive from 2009 was given under the wrong legal basis. But it is a complicated issue. It's not clear what it means. It's also not clear what does it actually mean. Does it mean that a member state can opt out Or does it mean that EU cannot regulate? Or what does it mean? Or is there some sort of de minimis requirement there because anything will impact somehow? So you do have to have some sort of threshold, but where the threshold is of course, a question.
Thanks very much. I have, I'm hesitating to call these the killer questions, but I'm going to ask them anyway. Alejandro, I'm looking at you first, and I'm asking you and not the IUCN. Is there going to be an ILBI ultimately? I would be curious in your what you expect. And my question to Till is concerning import bans. What about WTO law here? Is that really so easy to follow that path? And then we have another question here saying, can you give examples of states that argue that MGRs are covered by Part 11 of UNCLOS? Interesting. Yes, please, go ahead.
Well, so your killer question, you know, I think it's a question that we all need to be thinking about. I mean, it's not only for me. I think it's also for the experts, you know, present here. If I look at the way in which, if we follow, you know, I put a slide with the sequence and the way in which the legal regime and the negotiations are advancing, you know, and there are certainly back and forth issues here, and contentious issues, you know, in New York, and they will not disappear. They might, let's say, put on hold for some time, but they will resurface at the end of the day. I'm quite optimistic, let's say. I am optimistic about that. I think, I don't know with whom it was during the lunch break, I think the lady working in the EU, somewhere she's sitting. Yeah, exactly. So we were discussing that oceans issues at the global level are getting a lot of traction, you know, beyond, let's say, what is happening in New York with these big conferences, you know. And our own organization is also reacting to that. I was explaining that to you and to another colleague, that for the very first time, IUCN is going to adopt next year in the General Assembly in Marseille the new program of work for the next 4 years, in which we will have a distinctive program area for the oceans. You know, in all the years since its creation in 1948, IUCN was primarily concentrating on terrestrial issues, terrestrial biodiversities, you know, extinction on Earth. And the sea was always the last frontier. So now we're going to move much more prominently into looking at the sea. And this is not because of us. This is showing that the world is really moving and re-evaluating and reconsidering, you know, the role of the oceans, you know, in different ways, you know, food, climate change, and so on and so forth. Therefore, you know, I think I'm an optimist as far as this international global regime for areas beyond national jurisdictions are concerned.
And the examples, could you?
The examples, well, I don't know. On the top of my mind, if that person, I don't know who that person is, can give me some couple of minutes, I will try to look at, you know, the reports of the latest negotiations, and then I can certainly find something. But there might be some people here that are very silent, and they might know an answer on that. Yeah, do you know that? Exactly. That was going to be my guess, but I just wanted to confirm that.
Did everybody hear that? G77
G77
plus
and
China.
China, yeah.
Thank you. Also, thanks to you. Did you want to make it? All right.
She's the expert, you know. She has a PhD on those issues. I mean.
All right. Till, the challenge will be to try to answer a broad question in comparatively limited time.
Yes, it's so funny that you asked me that question, because the first time I stumbled across that question was when I read a
part of your PhD thesis. and you mentioned that the EU was introducing trade bans for tuna products from Belize and I don't know, some other country. And the EU, when it introduced these bans, they very, very thoroughly listed the arguments in the regulation, in the preliminary introductory remarks, and you could see that they took these criteria from WTO appellate bodies' decision, from the panel, and now, well, the main objective is, of course, that you do not arbitrarily or introduce disguised measures of market protection. And today and in the future, RFMOs will play an important role in this regard. So it's a very clear indication if an RFMO says, here, this ship is being involved in illegal fishing, and that gives a very solid ground for the EU to introduce trade bans under the IUU regulation. And so, but it needs to have objective reasons and criteria, not to go against WTO rules.
Thanks very much. I was, I mean, you paid me back, yes. And that was a good way to deal with it. But I think it is also a question which has to do with this issue of fragmentation, which has popped up again and again in the course of this conference. We also have, and you mentioned it, Kim, we also have this entire realm of WTO law involved in the matter, and that doesn't make it easier, I think. We have one final question which came out of cyberspace, and that is addressed to Kim Thales, asking how are international energy projects balanced with the protection of the marine environment?
That's a difficult question, of course. If you were here yesterday and the first speaker talked about the Antwerp harbor, take out Antwerp harbor, put in energy project, and you'll have an answer. That's for Europe and European Union and OECD countries, let's say, developed countries. Outside of that, today the energy world is not what it was a long time ago. Today the pressure from shareholders, NGOs and media is immense. And therefore today that functions as a stick and a carrot to being responsible environmentally.
Thank you very much. This ends our discussion. I think also in this third panel session, we heard excellent presentations. We had a wonderful round of discussion. So it is the time to give a round of applause to our three distinguished speakers. Now, please don't leave the room because we have another highlight, and that is we tried at least to do something innovative here. We decided to do a project with schools in order to give the young generation the word on a particularly important subject, but also to create awareness and to contribute to create awareness to the important issues concerning environmental protection and marine environmental protection in particular. And I would like to give the word to Rhoda Verheyen, who is a member of the board, who's going to introduce you to this project. And then we will see, I think, even a performance, which is great.
Let's hope so, yes. Well, thank you all. My name is Rhoda Verheyen. I'm a practitioner. I'm an environmental lawyer in the city. So is another board member of your host, which is the association, the HIELC Association. And as you may have noticed, if you have read your reader, we are here in a city which has a lot of education facilities. I read there's 19 universities and over 100,000 students. We have even more pupils in schools in the city. And since one of those universities, the University of Hamburg, is 100 years old this year, there was the idea to get together with the conference here and the university and actually try to engage, interconnect, as we've heard. We're an interconnector now, with pupils in schools. So this is what mainly the university has done. Professor Kotzur and Ivo Appel, who is sitting right there, who didn't want to do this part for some reason, I don't know why. So what happened was, there was actually a major effort made. There was schools contacted. There was project days, or several project days, participated by several professors and Jorina Zuko and her team, and in several schools in the city. And the overall topic was the harbor and ship emissions. And what came out of it is what I have in my hand and what will appear on screen in a minute. And there's also already some of the participants in the room, I think, up there. Not all of them are here yet, because one of them has actually injured his foot, I'm being told. So I wonder, is he now here? No. So what do? Do we just reverse the... Ah, okay. Great. Well, let me just tell you a little bit about what we actually received. I mean, obviously, this was a tool to actually engage on issues of environmental policy and law with students. Yes, he's here now. The injured foot just enters the room. And we received very interesting things, let's put it that way. We received songs and raps and placards and artisty things, and of course interviews, videos. And what we did then was get together, actually review them all. We had all the students that actually delivered projects to us come to the university 2 weeks ago, and we then had the very difficult task of actually determining the first, second, and third place. And there's also prizes, of course, which I will now have the honor to actually deliver to the participants. So if I can now, thank you for now giving me the slide here. If we should just move to third place now, you have to get up again now, and come down. And the third place is, let's give a round of applause to him, because he's, so this is Krikor. He's making his way down. Do you want to say something yourself when you come up? Yes. Oh, very good. I promised to actually ask people whether they want to speak in front of an audience like this in English. Hello, it's very good to have you here. Thank you for participating.
Thank you very much.
Let's have a look at your film first, and then maybe you can say something, yeah? Oh, he wants to say... Oh, okay, he wants to say something. Yeah, okay, I'll translate for him. Ich muss das machen. Okay, I'm being completely useless here. There you go. So.
Hallo, schönen guten Tag. Zunächst erstmal vielen Dank, dass ich hier sein darf. Dritter Platz, habe ich mich sehr gefreut. Aber mein großer Dank geht auch an Frau Giedmann, meine Klassenlehrerin, die dafür überhaupt gesorgt hat, dass wir hier an diesem Projekt teilnehmen dürfen. Vielen Dank. Des Weiteren geht mein Dank auch an Jorina, Laura und Vanessa, die uns dieses Projekt überhaupt vorgestellt haben, denn ich wusste ehrlich gesagt vorher auch nicht, wie es um den Hamburger Hafen aussah. Und dieses Projekt hat mir sehr weit geholfen, mal etwas auch für Hamburg zu tun. Und dies wollte ich in einem Infofilm zeigen, indem man seine Infos selbst rausnimmt. Also nicht etwas, was ich vorspreche und jeder nimmt das auf. Also jeder soll das wirklich mitnehmen, was er auch möchte. Das war mein Ziel. Ich hoffe, ich habe es erreicht. Vielen Dank. Thank you very much.
So now I'm there we go. Okay, and I will move up. Yeah. Okay. So what we did now, of course, we put in the English translation, and it just runs through without me clicking. So just have a look at what Krikor did for us.
So Fragen, of course, is questions, right? Are you content? Yes. So given the attraction of the harbor for the city, of course, the tourists are very relevant. Another set of questions. And this is a big survey and took a long time, as you may imagine. I want to know how you detected the tourists, how you knew that they were tourists, you were asking. But of course, you recognize them, and you were actually in the harbor often. So we thought this was very impressive. Somebody just going, out and getting together with so many people in the street and actual, doing a survey, statistical survey. And now what we're looking at now is Krikor actually addressing the political parties of Hamburg with these questions. And he's written to all of the political parties in Hamburg about these issues. He's only received a few responses, unfortunately. But, it was very, as I said, it was very impressive to us that he's made this huge effort of actually raising awareness for himself and also for his school, I'm supposing. And what we're seeing here now is the responses from the CDU, which is the Conservative Party in the Hamburg Parliament. And as you know, Hamburg is not just a city, but also a federal state. So Hamburg does have some weight in making laws and actually changing things in Germany as well. Port state control is an issue that Hamburg can actually influence to some degree. Are we still looking at the CDU? Yeah, I think so. We're just running through this now, and I think there's now a survey coming back from an NGO, which is the Nature Protection Association, the NABU. So he's put all of these very politically pertinent questions to not only political parties, but also to other stakeholders, as we would call them in law. And this is a survey that came back from the Naturschutzbund, which is one of the largest environmental protection NGOs in Germany. So I'll let you read it a little bit. And of course, what's interesting is that this very association works very prominently with luxury boats and cruise ships in the city to actually make the air cleaner, because the real issue here is climate change, but mostly particulate matter and actual air pollution in the harbor, sulfur emissions. And cruise ships are becoming to, or are getting to, or are already a big problem in Hamburg and other harbor cities, I'm supposing, worldwide. I know this is the case in Sydney and in other areas of the world, I'm sure as well. So this is, I think, some of a summary that you did with these little graphs. And you can see now, we need transparent rules. I think that's, everybody can agree to that after this two-day conference. Is this being translated? Yeah. So there you are. Okay, and this is it. Thank you very much. I'll come back. Thank you very much for participating. This is the third prize. And just stay seated. Thank you very much for participating. I think this is 100-year university events. So this is great. Yeah. So the second place is 3 young men that may come down now. If you're, are you okay with coming? I know you don't want to speak. You don't have to speak. I'll just ramble on. Don't worry. But so what they did was more of a mixture of an interview, or several interviews, and a placard, which I found very interesting. It says, is this translated somewhere? No. Yes? I'll just carry on. It doesn't carry on. It does carry on. So, sports makes you ill. Well, renders you sick. But only if you actually do some jogging or basketballing in the harbor, because that's where they got their idea from, I think. So the Brechtschule is where they come from. This is the placard that I have here. Toxic air in the harbor. But of course, that's not all they did. They conducted interviews. Do I just carry on? I just carry on. So, do you want to read this out? So they've become aware of the bad air caused by ships in the port by a lecture of the university during the project days that I mentioned. And they asked ourselves how many people feel disturbed and impaired. And then they came up with starting a survey in the port area. And that's because, of course, the port area is also a great big living area now these days, because the city of Hamburg has decided to develop living areas basically right where the cruise ships land, which is interesting in itself. So they met on a Sunday in the Hafen City, which is where we were yesterday, actually, and started the survey. And the Lose Park is actually a recreational area where you can basketball and whatnot, other things. And here are some survey results of the basketball players that they met there. So Torben, who is 21, says, I noticed that the longer I play here, the quicker my physical condition decreases, but when I meet up with my friends in the city park, which is not near the harbor, I can keep on much longer. So that tells you something possibly about the air quality in the harbor. Klaus, 32, says, I only play basketball here when I know that there are no cruise ships. That's quite extreme, I think. Claudia, 35, and her daughter, they say, she says that her husband often plays basketball here, and we enjoy watching and enjoying the views of the harbor, but when there's a big ship anchored here, my daughter always starts coughing. Now you've made me think that might be the bad air. Well, let's hope it's not the bad air. But it's quite interesting when you read them. I was quite impressed. This is never mind. So then they continued walking through the Hafen City and came up with this quote. Mrs. Meyer, 75 years old, from Altona, and who's walking her little dog. I always come here on weekends, and I'm happy when the cruise ships arrive or depart. They belong to Hamburg and the shape of the harbor scene and bring many tourists. It's good for the city. Why would they be harmful? Don't make such a drama. Very representative survey, isn't it? Are you surprised? And Hans-Peter, 65, from Dresden, my wife and I always visit Hamburg twice a year. We're especially happy when the Hamburg Harbor birthday is celebrated. It's a huge festival with, I don't know, hundreds of thousands of visitors, I think, each year. We enjoy watching the inlet parade, ships essentially, and are happy about the big ships. We've never thought about the pollutants that are emitted, which is interesting because certainly at that time of the year there are many ships that have not very, or let's say not state-of-the-art pollution retention systems. There's a jogger, and he says, I run here every day, and I've never thought about emissions. I think I really have to find out. And Eric, leave me alone with this. Shipping is an important economic factor for Hamburg on which many livelihoods depend. What do I care about the emissions? I can't hear it anymore. It's quite extreme, that guy. Was he very unfriendly? War der unfreundlich zu euch? No. No, he was friendly, but drastic. So, and then two mothers, mothers with her twins, two mothers. One mother with two children in a stroller. When I know that there's big ships, I'd rather stay inside. So, well, and René, I've lived here for a year and a half, but if I had known how loud it was, because that's also an issue in the Hafen City, and how strong the smell of the diesel was, I would have never bought the apartment. And I do know that there are several people who actually live in the Hafen city that think this way. So to conclude, when we were in the Hafen city that Sunday, there was always no big ship in the harbor. The sky was blue and the air seemed to be clean. That's why we were so surprised that so many people complained that much about the exhaust fumes from ships. Nevertheless, the situation in the harbor is of course precarious, and that gave us the idea to design the poster. Oh, sorry. And the poster, I show it to you again. This is what they did with their artistic skills, and I think this deserves a round of applause. In the second place, okay, so 1, 2, you don't have to speak either. And take your placard, and thank you very much for being here and okay, so yeah, made me think too. I don't go to the harbor with my kids very often, but never mind. So the last one is, come down here, guys. But don't you find the level of engagement quite impressive? I mean, for pupils this age, that they actually go down and actually engage with these issues in such depth? I think it was. So they did a little bit of a different thing, and I won't tell you a lot about it. You tell me, do you want to do this, or do I just start, or what do you want to do? Okay, they want to speak, and I'll move out of the way. Soll ich das übersetzen? Du kannst das so. Bitte.
Hello, thank you for having us. We made a rap, and how we came up with this idea, because we thought, how could we deliver such an important message to younger children that they can also think about it? So we decided to make a rap, and we all together wrote a lyrics, and I took it with my phone, and I made a rap out of it with an app.
With a music app?
Yes.
Hier?
Wo?
Ja, ich glaube, genau. Okay, so, oh, sorry, I never actually introduced those three people here. So Olivia, Chantal, and Julius, and I think you can now start your rap. There you go. So this is the verse and the refrain, and they actually did this in English to start with, so nothing had to be actually translated here.
Yes.
Everything you do is in slow-mo. That ship's waving like a yo-yo. No more gas, that's a no-no. You're playing with the earth like it's your soul. Too much carbon in the air. Our lives count too, that's unfair. I hope we can live, that's a swear. That emission is a fair. Millions of millions you already spent. Hello, man, speak to the president. You got a lot of work to do. Things you did were only right for you. All this shit is to blame. Every day is still the same. My God, it's so lame. Don't you think it's a shame? I'm not doing this for fame. You should stop, it's not a game. Meanwhile, the sky is gray. You say we gotta pay, and if you want that we stay, then please don't go away. For the world you have to pray, and that's all I gotta say. Our city has a lot of history. How we got to this point is a mystery. You know we are the majority, while you are just a minority. The environment is crying because our animals are dying. Let's do something for charity and bring in some clarity. And stop thinking about the bill. It is in our will. Don't let the port overfill and be 100% real. All this shit is to blame. Every day is still the same. My God, it's so lame. Don't you think it's a shame? I'm not doing this for fame. You should stop, it's not a game. Meanwhile, the sky is gray. You say we gotta pay, and if you want that we stay, then please don't go away. For the world you have to pray, and that's all I gotta say.
Yeah, quite good. So the first prize is for Olivia and Chantal and Julius, but actually the prize is for their whole class, and it's an excursion to Bremerhaven, to the climate house there, which is actually very interesting in case you haven't visited it yet. So here you go. Thank you. Well done. Thank you for participating. Okay. So, yeah, congratulations, and who's to close? Alexander. Okay, thank you very much.
I have to say that I'm so impressed. Congratulations also from my side. It's not that easy to come up with some closing remarks after such an intense rap and accusation, which is legitimate, and it should make us all think a little more about what is going on, as should the Friday demonstrations of the young generation also do, I think. Now, I still have to make this cut here and be official again, in a way. The program says that I'm going to give a closing, or rather someone is going to give a closing speech. Don't worry, I'm not going to do that. Hang on, maybe another presentation for 45 minutes or something. Just give me my notebook. No, don't worry, I'm not going to do that at all. I just want to use this in order to say thank you. But before I do that, allow me to share just very few reflections. Not on the content, because I think the speakers were all so clear and concise, and the discussions clarified many of the issues. I don't think that's necessary, but I would like to address the issue of what is the purpose of an international conference like this? And this question came to me the day before yesterday when I gave an interview with a reporter, a journalist from the northern German broadcasting radio station. And she asked me this question: what is your expectation? Why are you doing this conference? And I gave an answer. I'm not going to repeat that, but afterwards, after the interview was done, I thought, wow, that's a good question, because it seems to depend very much on whom you ask. And indeed, for us academics, the question is not really one, right? Because that's what we do. We organize conferences. We do networking. We meet with our colleagues and friends, and we discuss controversial issues. We try to have an exchange on legal subjects that are all of high interest for us. But in a way, it's also part of a certain routine, isn't it, of the academic world? It simply is what we do, have conferences. Now, should there be more? And I think, yes, there should be. And I was wondering, and I am wondering, whether we were successful in achieving that. What is it then? Academics cannot implement regulations. We are not regulators, but people from regulatory authorities are in the room. What we can do is try to develop new approaches, try to make things understandable, try to shed light on very complicated issues. And I think that is something which became very clear in all presentations. We are addressing and dealing with a very, very complicated and controversial issue here. Fragmentation is one of the words, norm collisions, regime collisions, colliding values, balancing exercises. All this is very, very difficult to do. It's also about addressing gaps in the regulatory regimes to create awareness also. But I think one of the main issues that we have tried to do, at least, is to bring together people from academia on the one hand and people from legal practice on the other. I had a couple of talks during the coffee breaks with people saying, well, this is all extremely interesting, and I keep wondering, what does that mean for my everyday business? And sometimes, and I guess that is something that most of you will have experienced, sometimes there really is also a gap between academia and practice. We deal with academians, we deal with questions that maybe are not that practical relevant all the time, which kind of, are somewhere in the air. And people in the regulatory authorities, they have questions and they are facing massive challenges on how to apply this very complicated regime. And sometimes we don't seem to deliver all the answers to that. Maybe that's also not possible, but maybe we should try to do that more. And what I think is true with regard to all speakers is that all of them try to do exactly that. And that is because most of them had both an academic background and a background and a lot of experience from legal practice. And that is what I particularly enjoyed in the context of this conference. And my hope, and I think I'm speaking on behalf of all members of the board here, is that this is also the feeling and impression that you got during the last 1.5 days. Something that we should definitely focus on is to try to fill that gap between academia and practice. We are not only addressing these questions for the sake of theory, but rather because we have to provide solutions, something that the students, the school students, also claimed, and they justifiably did so. Having said that, I would like to move on to words of thank you. The first group of people I would like to thank is the speakers. I think you all did an excellent job. Thank you so much. The second group of people I would like to say thank you are the discussants, those that asked questions, commented upon the presentations, and all of you, the participants, for your interest in the subject matters, for coming to Hamburg, and for staying here all the time, listening carefully to what our speakers said and submitted, and I think that also deserves a round of applause. On a personal note, I would very much like to say thank you to my dear friends and colleagues from the board of the Internationale Umweltrechtstag, both from the people that are involved in the scientific advisory committee, but at the same time to all those that are members of the board. It was great fun, I think. I enjoyed it very much, and I would like to say thank you for that. And also you deserve a round of applause for that. Last but certainly not least, there is one person, and behind that person, a team of young law students without whom this conference could not have been possible, and that is Jorina Zuko, who has been responsible for the entire organization. I think you did an excellent job. We are all very, very grateful, and our gratitude goes also to the entire team. Thank you so much. And this leads me to, on behalf of all members of the board, wishing you all the best. Have a safe trip home. Thanks again, and as I said before, I'm pretty sure there's going to be another edition of the Hamburg International Environmental Law Conference, and we will keep you up to date. One final remark concerning the outcome. We have offered to all speakers, and I learned that many of them were kind enough to accept that offer, to have their papers published in a special journal, in a special issue of the Journal for European and Environmental and Planning Law, which is a German law journal, which is, I think, highly recognized. And once that is done, we will keep you informed about that in order to make it possible for you also to study what has been said by our speakers. Thank you very much. I wish you all the best. Looking forward to see you again at the next opportunity. Take care.